Pass over item number 8.
Last, do you know this? Every day this matter is being called. So the counsel is not there. So it's a jail criminal appeal. Must have been engaged by the. Uh, if he's not interested, then we can change the. Because of the fact that he filed the bail application, that's why we, for last 3 days, we are adjourning. So, যে মানে engagement কেমতি আসছি মানে legal state legal services ରୁ ହେଇଛନ୍ତି ନା sounds no.
We hereby appoint.
Acha, this is
Amicus.
2014.
That was court has appointed.
So we can change.
You will change.
एहसान को list दे देवे. We for that. When they
Keep it.
Keep it is for it. Dita का matter है. All right, next. 8 में छाड़ दियो.
Item 12.
Convicted for life for the offense under section 302. Convicted for life for the offense under section.
Mike टा के पाखु नहीं तो शुभुनी.
Person has been convicted for life for the offense under section.
Which item it is? 282.
He's in custody since 15/9/2015.
Custody since
15/9/2015.
15/9/2016. 15. And what is the conviction and what is the sentence?
And convicted for life
302. 302.
Yes,
Achha.
302 and 307. 307 is also there.
307.
Yes, sir.
302 life imprisonment and for 307 7 years.
Yes,
2000 fine. So one deceased.
Right. Yes, sir.
What is the name of the deceased?
Arjun Singh. Arjun Singh.
Date of occurrence?
Date of occurrence 28/8/2015.
Your bail application was earlier rejected?
No, my lord.
And another injured is there, my lord.
Yes, sir.
His name is Nayak Bandara.
Injured is PW?
7.
PW7.
PW7. Okay. No, you want to see that whether it has been rejected earlier or not. Okay, not rejected. So eyewitnesses obviously injured must have been must
No,
be there.
yes, not eyewitness.
Injured is not
1348 are the eyewitnesses.
Who are the?
1348. One is the villager. 3
1, 3, 4, and 8.
3 is the mother.
3, 4, 8.
4 is the brother, and 8 is the
Okay,
wife of the
4
deceased.
eyewitnesses are there. And injured must have supported also the person.
Yes, ma'am.
Okay.
Yes, ma'am.
And doctor is PM doctor?
Doctor is PW 16 years.
Yes, ma'am.
And doctor who examined PW7?
12 and 13.
12 and 13.
16 30 बाहर करो. Okay, one blow has been given.
Yes, sir.
What is the weapon of offense?
Knife.
Bhujali. No, Bhujali.
Back of the chest,
Yes,
left chest. The date we have to check charge sheet. Final form. Prabhupurti 15/9/2015 ठीक है. और सीटा देखिले बात भी नहीं देले. Custody produced in custody. is also produced in custody.
या ଭିତରୁ ଗୋଟେ କୁ interim ଦିଆଯାଇଛି କି
ମାନେ
happy alias
criminal appeal ଜଣେ appellant ନା
ଏଥିରେ ଜଣେ ଟୋଟାଲ ଏକ୍ୟୁଜ ହେଲେ 3 ଜଣ
3 ଜଣ ହଁ ନାଇଁ 4 ଜଣ
4 ଜଣ
ହଁ
what happened to them the other
others
person
have been acquitted.
acquitted.
oh, others have been acquitted okay you have never been released on bail during trial so it is 8 years and maybe 9 months you are in custody. And what injury has been caused to that PW?
Grievous injury, hand finger ଟା ଛିଡି ଯାଇଛି.
Acha, doctor is PW
13 and 12.
12 and 13.
12 did the X-ray. 13 is the doctor who treated the PWC.
Hattare middle finger
Injuries grievous.
So any criminal antecedent against
No, that part I have not accepted.
Not similar.
anything on record there?
No, madam.
Nothing. And that too extrajudicial confession is also there.
So that's there, but
PW5.
ତାର ଏଜ୍ ଟା କେତେ ଏଜ୍ କେତେ ତାର
Age of the
Young,
23 years. Acha,
no, age of
30,
31 years.
23 years in while filing the appeal means you'll be around let us say 21. Okay, you do one thing that bring that criminal antecedent. We'll take up this matter next week. It is to come from Sarat police station, right? Okay, take down IA number so and so. This is an application for bail. During the hearing of the bail application, learned counsel for the state seeks some time to obtain instruction about the criminal antecedents, if any, against the petitioner. So it can be taken up next week. Put up this matter in the week commencing from 1st July 2024. Yeah.
Okay.
Item 14.
This matter was also called regularly. Change the advocate. Change the advocate. Next.
Item 15.
ଆସୁନାହାନ୍ତି ଯଦି ଅମାୟିକ ଆମେ
ଯଦି ନା ଆମେ MATS that means if they're not running
jail criminal ଆସୁନାହାନ୍ତି
will ETC ଦେଇଥିଲା ଗୋଟେ jail consistent you can't really
no. Yes.
Last occasion, Lordship
Which item?
is in appellant is in custody for more than 10 years.
14 wala pra?
14 or 15 item. Item 15.
Oh, 15. Just a minute. Yes.
Appellant is in custody since 2/8/2013.
2/8/2013.
And last occasion, your Lordship's called for a report
no.
regarding local inquiry as to whether if you will be released on bail, is there any
Already appellant sent the same.
ठीक है High Court judgment. Judgment case number 1 same case. At antecedent
Antecedent ଘଟଣା ପୂର୍ବରୁ disease
Mrs. Sahu,
My lord.
we have asked you to collect information if there is any antecedent,
My lord.
but you have given the same case number. Is it an antecedent?
antecedent your lordship has called for a report because the informant has earlier there was a case of rape allegation against this appellant by the daughter-in-law of the deceased in 2011. So allegation that in this case that after 2 years deceased died, who is the mother-in-law of that victim. So in that case I convicted, so and undergone the period. Your lordship, that is the whole motto and motive of the case. Then in that case, on the basis of strong motive, I was convicted. Apart from there is evidence that on the night of occurrence, I was near the house.
No, you were earlier, there was a case under 376.
Yes, 376 against the daughter-in-law who has lost the FIR.
No, whatever. You have also been found guilty.
Guilty and undergone.
The same police station.
Same police station by the daughter-in-law of the
How it has
deceased.
not been mentioned here.
In the judgment, it is mentioned.
Judgment, it's all right.
That is the whole motive
Where
of the
is
case.
that judgment mentioned? We will call for an explanation from that IAC. Not in board, huh? Food lekha hai ji, Mr. Jafrullah.
My lord. My lord, I would like to say, internal page 11 of the impending judgment. ତିନି ଚାରି ଲାଇନ୍ ରେ 4 ଲାଇନ୍ ପରେ
in city 343
ଆଜ୍ଞା
and 11.
ସେଇଟାରେ ଲେଖା ଅଛି the certified copy of the judgment passed in city number so and so which reveals that accused Neelu Swai was convicted for offense
376
511 376 511 in a case initiated by the victim of the
he has relied upon money. He relied according to the London public prosecutor, murder of the deceased by the accused Neelu Swai with such a motive can be said to have been established in view of the in support of submission. He has relied upon exhibit 12. Exhibit 12 ta har kale jo trial court judgment ra text of exhibit 12 ta har
this is the judgment. May send this.
the 8 exhibit 12 ta khojiba eguta judgment
ସେଇଟା ହଉଛି judgment.
acha ठीक है city author worker se judgment or se relevant page ta city case number 343
city 343
case number 3 SDM board was given before Jashpur Town Police Station. So Raj, Jashpur Town Police Station, same police station. Mrs. Sahu.
My lord.
So not only the judgment reveals that there is another case, the London a public prosecutor also produced this copy of the judgment which has been marked as Exhibit 12. He has also produced, we find that that was also a case under section 376 IPC of the
Right.
same police station.
Madam.
And your IIC is reporting that
Not
just see
related.
this line, except this case means the present case in which that he is not involved in any case. So he's
Absolutely.
in portions of the order dated the IN number 67 of 2019, heading related, an application for bail on 16/5/2024 when the matter was taken off. After going through the impugned judgment, we directed the learning counsel for the state to obtain instruction through the inspector in charge of Jajpur police station regarding criminal antecedent, if any, against the petition, and the report to indicate whether there is any chance of creation of law and order problem if the petitioner is enlarged on bail, looking into surrounding circumstances. Today, the Land Council for the state has produced the report received from Inspector in Charge, Jajpur Police Station, dated 24/6/2024, wherein it is mentioned as follows, quote the entire thing. Jajpur PS case number 123 of 2013, dated so 18/6/2023, which is mentioned in the report, is the very case out of which the present JCRL JCRL number 80 of 2018 arises. However, on going through the trial court judgment, we found that the submission was made by the London public prosecutor that there is strong motive behind the commission of crime, and he relied upon Exhibit 12, which is the certified copy of the judgment passed in city case number 343 of 2011, which revealed that the petitioner was convicted under section 450, 376, 511 of the Indian Penal Code in a case instituted by the victim of rape, bracketry, the daughter-in-law of the deceased. Exhibit 12 available ଅଛି ତ? Exhibit 12, we also peruse the Exhibit 12, which reveals that the said case arises out of Jajpur Town Police Station, PS case number 156 of 2011, which corresponds to GR case number 498 of 2011 from the file of SDGM Jajpur. Therefore, the report which is furnished by the IIC Jajpur Police Station, dated 24/6/2024, that except the present case, bracket out of which the JCRLA number 80 of 2008 arises, the petitioner is not involved in any other case, is apparently a wrong statement. The inspector in charge filed affidavit as to why
Suppression.
why he has suppressed the fact regarding the involvement of the petitioner in another case, and why proceeding under contempt of court shall not be initiated against him for giving such false report. in the report, it is also mentioned that there is no chance of creation of law and order problem if the petitioner is enlarged on bail, looking into the surrounding circumstances. Stop. We intend to know that what inquiry has been made by the IIC to arrive at such a conclusion. The inquiry report shall also be furnished along with the affidavit. Hello? Copy of the order be handed over to the Land Council for the state. The report furnished by the Land Council for the state is taken on record. Better they don't. Yes.
Next.
Matter ଗୋଟେ ସପ୍ତାହ ପରେ ଛାଡିଦେବ 8 ତାରିଖ ପଳେଇ ଆସିବ।
Item 16.
May I please, Lordship? My Lord, the appellant is in custody from the 1st June 16.
Just a minute, just a minute. Yes, what is the custody date?
8 year, my Lord.
No, please tell. If you have got the date, exact date, tell us.
Yes, exact date, my Lord. Not what the next day he was arrested, but date of arrest is not mentioned in examination IU or in judgment.
Just a minute. Trial court judgment, a final form.
Original petition আছে 2/6/2016
না হচ্ছে কোন রঙ্গা দেহুরি
2/6
রঙ্গা দেহুরি 2/6/2016 2/6/2016. Have you not been released on bail during trial?
No, my Lord.
Wait, let us verify it.
judgment was on 30th of April 2008.
Produced in court. Pronounced in court. So, okay, he has not been released. And during the pendency of this appeal, you have also not been released on bail.
No, my Lord. This is first time before Lordship, my Lord.
Alright. So, you have been found guilty under section
302, my Lord.
and life imprisonment sentence.
Life and
So, whom you have killed? What is the name of the wife?
Raimuni.
So, you killed your wife. What deceased name is?
This is name is Ranga Deuri. No, sorry, Raimuni Deuri. Raimuni Deuri. Appellant
Raimuni
is Ranga.
Deuri, the wife of the appellant.
Appellant.
Stabbing on the neck.
Also, stabbing on the neck.
It's a sharp-cutting weapon that is knife.
So, it's a case based on circumstantial evidence?
Yes, man. Circumstantial evidence. There is no eyewitness, my Lord.
It took place within your house. The dead body was found inside the house.
No, my Lord. They continue quarrel. On the said day, they quarrel and they rush to the 200 meters of the jungle. They are residing. The place is a jungle area. Thereafter, my Lord, the PW1 getting the information, and when they have been to the spot, the Raimuni was the dead body of Raimuni was found place.
Inside the jungle,
Inside the jungle.
not in the house of the
No, not in the house. Inside the jungle.
So, both of them were seen together while proceeding towards that jungle. That means the appellant was chasing the deceased.
No, my Lord. My Lord, the informant stated that PW9, before they rushed to the jungle, they quarrel. Prior to the occurrence, they are continuing their quarrel. Thereafter, they rush. And PW1 stated that PW1 is a nephew, my Lord. He stated that in chief stated that the appellant confessed before me, and in cross stated that he did not confess before me. In para number 2, my Lord. PW1.
So, Mr. Counsel, so extrajudicial confession is also there.
My Lord, as per the statement of PW1, my Lord.
PW1.
My Lord.
So,
He killed her by stabbing, my lord.
Right,
By
that is
means of knife.
the. What else is there, Mrs. Sahu,
My
apart from extrajudicial confession?
And
Other,
recovery of the dead body is the
Still the dead body, my lord.
that's concealed underneath the ark.
कहाँ
Get covered.
IAC?
Then the matter was reported to the police and came to the police and went to the state general. He and
No. On the
27 is there, my lord.
27
And
is
as per
there.
the
Accompanied the police to the said spot. They found that in fact the deceased was lying dead at the said spot having a punctured wound on the neck. 27 is there.
my lord.
who has stated about that?
PW 10, my lord. In
Let
our
us see.
cross examination, para 6,
PW 10.
PW 10, my lord.
No. He is accused confessed his
Confess,
guilt
as per
before
their
the
statement,
police,
para
Yes.
6, my
and
lord.
he gave recovery of the said knife.
My lord.
So knife, it is not the dead body. We are knife
Dead body
recovery.
रे भी चला knife and knife.
अच्छा.
Stab wound is there.
Right.
One wound is one stab wound. PW 13 is the PM doctor who has noticed one stab wound of size 3 cm into 4 cm into 4 cm on the right side middle portion of the neck, along with the injury to of the great vessels. Okay. And he has opined the cause of death was due to hemorrhagic shock resulting from injury to right carotid artery. No, the IO who has stated PW 15, he has not stated that
No.
the dead body was recovered at the instance of the that is,
No.
he stated that it was lying in the ମଙ୍କଡଗଡା ଅଭୟ ସାହି ଜଙ୍ଗଲ ସେ କହୁଛି ସେଇଠି ଇନକ୍ୱେଷ୍ଟ କଲା ଇଏ କଲା ତେଣୁ yes you are right that knife was seized at the
As
instance
per
of
the
the
judgment, para 12, para 13, my lord, on the last 4 line.
where is the material that they quarreled with each other? Extrajudicial confession is there, but he said that somebody has stated that they quarreled with each other and the appellant was found chasing the deceased towards that jungle. Where is that evidence?
As per the prosecution allegation, my lord,
No,
the
prosecution
deceased was
allegation
not
case ଆପଣ ଯାହା ट्रायल कोर्ट रे प्रेजेंट कले जो साक्षी माने देले कौनसी साक्षी कहिसंती कि एमानक
as per
भितरे
the
कଳି हेइथिला एवं ये ताकू चेस करिकिनी देखिबा कौनसी साक्षी कहिसंती
conviction basing upon the extrajudicial confession PW1
right
and PW
recovery of
doctor
that
report,
knife maybe
my lord, and doctor report, my lord.
doctor
Basing upon
report
the doctor report, my lord.
okay these are the three things
My lord.
And informant in this case is PW?
9.
Informant PW 9, my lord.
Okay, let us come to that. PW9. The occurrence took place. I had been to beat situation. I heard from the villagers so that the accused had murdered his wife. Huh?
PW9 is grammar.
Grammar with the informant, my lord.
After getting such information, I went to the spot which has a where the dead. हाँ, तामने report दबा पूर्वरु से dead body already हाँ देखी कि नहीं था अपने गला report दबा FIR FIR होची सौंसो उला जाइतला बड़े गतकाली सन्ध्यारे मांकड़ोरा तोड़े तांग घरकू मांकड़ चला पथ देई फेरुतला संसाय संस रास्ता मझिरे पड़ी
Seeing the dead body and statement of the my lord, PW1. PW1 told before the informant, my lord.
कौन सी वजह है उसी को So, are the London Council for the petitioner and counsel for the state. The London Council for the petitioner submitted that the petitioner is in judicial custody since 2/6/2016 and prosecution case is that the appellant killed his wife Raimani Devuri. There is no direct evidence. This case is based on circumstantial evidence. And the London trial court, basing on the extrajudicial confession made by the petitioner before PW1, recovery of the knife at the instance of the petitioner, so also finding given by the doctor bracketary PW13 conducted post-mortem examination has found the petitioner guilty under section so and so. And counsel further submits that there are good chances of success in the case and balance of convenience is in favor of the petition. And therefore the bail application may be favorably considered. Learned counsel for the state has placed the evidence of PW1, so also the evidence of PW13, who has noticed one star wound on the right side middle portion of the neck of the deceased and opined the cause of death due to hemorrhagic shock resulting from injury to right carotid artery. Considering the submission made by the London Council for the respective parties, nature of evidence adduced during trials, since the case is based on circumstantial evidence, and further taking into account the period of detention of the petitioner in judicial custody and absence of any chance of early hearing, we are inclined to release the petitioner on bail. Allowed stay realization of fine. Yes.
Item 18.
My lord, the appellant is in custody, my lord, since 21/10/2013.
Custody single appellant, Mrs.
Appellant petitioner, my lord.
Jone to jone
Only one appellant.
My lord,
date
single.
date kebe koile custody date
21/10/2013. The prosecution
convicted
story
under section
302/201.
302/201 and 302 is life imprisonment and 201 it is for 3 years and fine of
Yes, my lord.
rupees 2000. Okay.
The prosecution story is, my lord, the deceased father, my lord, informant that he killed his wife.
Just one minute.
PW4
फाइनल फॉर्म टा टिके देखिए डेट टा टिके चेक कर दो देखिए अच्छा ଆଉ
my lord, I am placed.
କଷ୍ଟଡି ରେ ଥିଲା ତ ପୁରା produced in custody.
My lord, I am.
Wait, just 1 minute. Okay. And earlier, your bail application has never been
No,
rejected.
my lord, this is the first time bail application
Okay.
has been filed.
Okay. So, as per the prosecution case,
Prosecution story, my lord.
the allegation is that you have killed your wife. What is the name of the deceased?
This is Neera Shah.
Nirosa, wife of the appellant. Okay. Case, how you killed your wife? What is the PM report
My lord,
finding?
no eyewitness, my lord.
No, it's all right. No eyewitness.
No motive, no quarrel, nothing, my lord.
Just we want to know that cause of death.
My lord, just I am placing the FIR, my lord.
No, not necessary to place the FIR. We just want to, who is the doctor who conducted PM examination?
PW12, my lord.
12, my lord.
PW12. PW12.
PW4 is, my lord, the father of the deceased, my lord. Who is the informant, my lord?
Just a minute. Cause of death, asphyxia, venous congestion, constriction, force of fingers. Acha. PM doctor.
Marriage was took place, my lord, 12 years back, my lord. There was no children. For that reason, there was
Any issue out of wedlock?
no, my lord, no issue.
No issue.
After 12 years, my lord, this occurrence happened.
So, any motive behind the commission of
No, my
crime?
lord, no motive. And
You are living a peaceful life. That is the
yes,
evidence
that
on
is
that.
the statement of his father.
Father
Only
is
that
examined as PW?
PW4, my lord, father
PW4.
of the deceased.
Father of the deceased. This is my daughter. 12 years back, I have given marriage. Okay. My daughter was living happily with the accused. Where the dead body was found?
My lord, in the backside, there was another Ghennu Shah. In his house, she went to take bath, my lord. There she was seen hanged with her sari.
Okay. In the house of the neighbor,
Yes, my
the
lord.
dead body was
Backside
found.
of her house, my lord, that one Gendusa, he was neither examined, my lord, nor in the evidence also he has not taken. That
Okay.
Gendusa, in whose house, my lord, she was found. Not house.
No, that is PW4 has stated also in paragraph number 1 that I saw that the sari was tied around her neck and she was on her knees in the pump house of Genusa.
Gendusa. And that Gendusa was not at all examined, my lord, neither by police nor in court.
What is your accused statement? What is your plea, defense plea?
His plea is, my lord, actual statement I don't have.
स्टेटमेंट पचराई देता हूँ क्वेश्चन नंबर 3 मैंने समझो तो ये से 2013 ମାନେ ୟାର ହେଲା 10 ବର୍ଷ 11 12 1 2 3 4 5 7 months 10 years 7 are the learning counsel for the petitioner learning counsel this Kasturi what is the name of this counsel appearing here Bhojraj Seth and Gyan Panda
That from jail, my lord, the appellant has engaged me, my lord. That letter is there, my lord. The record.
Subsequent orders will pass by this court. No. After the
Only
jail,
two,
हाँ ये भी अच्छी तो
only 2 months back I have received.
श्री ज्ञान पन्ना को अच्छा अपन को हाँ अच्छी as per the letter dated case one so recent letter that is 19/2/2026
on 7/5 order, I think.
अच्छी since as per the prisoner's petition received at flag E Mrs. C. Kasturi has been engaged as the counsel for the appellant. The name of the other counsel, that is Bhojraj Seth and Gyan Panda, shall not be reflected in the cause list henceforth. Stop. Are the learned counsel for the petitioner, learned counsel for the state? The learned counsel for the petitioner submitted that the petitioner is in judicial custody since 21/10/2013 and the prosecution case is that the petitioner has killed his wife, Neeraj Shah. It's a case, there is no direct evidence in the case based on circumstantial evidence. And there is no clinching circumstance available on record against the petitioner. The marriage between the petitioner and the deceased was solemnized 12 years prior to the date of occurrence. And they are having no issue. And father of the deceased being examined as PW4 has stated that the couple living happily. She further argued that the dead body of the deceased was found in the pump house of one Ghenu Sah, as a PW4 and a sari was tied around her neck and she was on her knees and that Ghenusa was not examined. Learned counsel further submit that there are good chances of success in the appeal and balance of convenience is in favor of the petitioner and therefore the bail application may be favorably considered. Learned counsel for the state, on the other hand, oppose the prayer for bail and praise the evidence of the doctor bracket PW12 who conducted post-mortem examination and has opined that the cause of death uh, might be due to asphyxia and venous congestion due to constricting force of fingers, and number of bruises were found on different parts of the body as per the PM report marked as Exhibit 8. Considering the submission made by the London Council for the respective parties, nature of evidence adduced, absence of any direct evidence, period of detention of the petitioner in judicial custody for more than 10 years and 7 months, and absence of any chance of early hearing, we are inclined to release the petitioner on bail allowed. Why you have filed 2 bail application, Mrs.
My lord,
Prosecutor? Your bail application is 5 to 7. Because
5 to 7, yeah, I have filed, my lord.
right, so the earlier application is not pressed. So 1895 is not pressed. Hello? Chaliye. Yes. 41 hearing by radiation. Yes, Mr. Nayak.
My lord, on the basis of a prisoner petition, my lord, I have been engaged in this case.
Please use the mic on any. देखो खराब है ना वो अच्छा तो दाखिल का सजड़ दो
My lord, on the basis of a prisoner's petition, my
Hmm.
lord, I am engaged in
yes
this.
there is no
Here, my lord, the appellant has been convicted under section 302 and sentenced to, my lord, undergo imprisonment for life. The present appellant, my lord, the deceased is the husband, my lord. Name of the deceased is Mangalo Mundari.
no case based on direct evidence or
No, my lord,
circumstances. Please come to the FIR.
My lord, page 19, my lord, the relevant portion of that. May I read, my lord?
Yeah.
Mu Srimati Lakshmi Badaik,
PW
PW 15, my lord.
15.
Swami
Yes.
Mangala Mundari, the deceased, my lord. ମୁଣ୍ଡାରୀ ବସ୍ତି ଜିରପାଣି ଥାନା ଜିରପାଣି ଆଜି 29/6/2011 ଏକ ଲିଖିତ ଇତର ଦଉଛି ମୁଁ ଗତ ପ୍ରାୟ ଏଟା 20 years ଲେଖା ହେଇଛି 2 years ହବ ଜିରିପାଣିର ମଙ୍ଗଳ ମୁଣ୍ଡାରୀ ପିତା
No, just a minute. He's dead. Her husband is dead.
her husband is
He
dead,
is
my
not the
lord.
deceased in this case.
This is the husband.
This is the husband.
No.
Mangala Mundari kept 2 wives, my lord.
Appellant's husband is deceased. Appellant's Adjournment is
Oh, is it this appellant is a lady?
Yes, ma'am.
Oh, I see. Okay, okay.
Here the PW
And
15 is the second.
how, just a minute, how this informant is related to the,
Second one.
huh?
second wife of the
Second. Okay. Second wife.
29/2001 ये एतला देउछि कि मु गत प्राय 20 वर्ष हेबो जिरपांडा मंगल मुंडारी मंडली 20 इयर्स that is 2 years जिरपांडा मंगल मुंडारी पिता जंगल मुंडारी को विवाह कर रही अछि मोर स्वामी सहित मोर प्रथम स्त्री सुनीता मुंडारी एवं पुओ झियो माने मध्य रहउछन्ति सुनीता मुंडारी सबुबेले अजथारे मोर स्वामी मंगल मुंडारी सहित कଳି झगड़ा करे सेथिपई मंगल मुंडारी जगदार टेंगुरु टोलारे मध्य मो पई गोटे घर कर दैछन्ति मु सेठारे रहे मझिरे मझिरे मु मो स्वामींकर जिरपाणी स्थित घर को आसे गत ता 27/2011 राति 8टारे मु जिरपाणी स्थित घर को आसिली खाईसारी राति प्राय 10टा बेलू मु मो स्वामी मंगलमुंडारी सहित भीतर घरे कबाट आउजई शोइथिलु बाट घरे पुओ सिली मुंडारी PW7 माइलर सिक्की मुंडारी शोइथिला एवं सुनीता मुंडारी प्रथम स्त्री
ये माने की एग्जामिन ହେଇଛନ୍ତି
PW7 मिलर सिक्की मुंडारी
सिक्की मुंडारी
आइना
PW7 ओके देन
एवं सुनीता मुंडारी माने द appellant
के तो appellant हो
सान झियो बिनिका हु हैज नॉट बीन एग्जामिन्ड सहित बाहर बारंडारे शोइथिले राति प्राय 12टा बेलू मु परिसरा जीवा पई घर बाहर को जीवा बेले सुनीता मुंडारी बाट घरे छिड़ा होइतिला कौन पई छिड़ा होइछि पचेरेरु से किछि कहिलानी या परे मु घर बाहर परिसरा करी फेरुथिया बेले मो स्वामी मंगल मुंडारींकर चित्कार सुनी कौन होला बेली घर भितरु दौड़ी जाई देखिली जे सुनीता मुंडारी घर भितरु बारंडा आडको दौड़ी पळै आसुथिला एवं मो स्वामी मंगल मुंडारी उलग्न अवस्था देह सारा जଳି जाई बाहर को प्राण विकଳରେ आसुथिले या भितरे पुओ सिक्की उठी तार बापा को धरी तले सुआई देला एवं आमे निया लिभालिभि कलु या परे मोर स्वामी मंगल मुंडारी को तांको देह को केमिति निया लागिला पचेरेरु से कहले जे बड़की सुनीता मुंडारी तांको देहरे किरोसिन ढाली निया लगाई दैछि पुओ सिक्की मुंडारी जाई ऑटो डाकी आनिबारे मु ओ सिक्की मिसी मंगल मुंडारी को प्रथमे साहू क्लिनिक परे CWS हॉस्पिटल को नेलु मात्र डाक्तर बाबू सेठारे आईजीएस जिया पई कहबारु आमे आईजीएस जाई सेठारे स्वामी को चिकित्सा पई भर्ती कलु गतकाली ता 28/2011 रिख उपरबेला मोर स्वामी चिकित्सा बेले आईजीएस रे मरीगले मो स्वामी देहरे सुनीता मुंडारी किरोसिन ढाली डियासिल मारी निया लगै देबारु से पोड़ीगले एवं जा फल तांकर मृत्यु ହେଲା एणु मु अनुरोध करिकि सुनीता मुंडारी विरुद्ध दूर कार्यानुष्ठान ग्रहण करछि
to come to the charge let us see that
on the page 23 man charges framed under section 302 on 7/1/2012
okay now the defense plea total denial
totally
so what are the basically the evidence one is dying declaration of course as it
dying declaration there is no such dying declaration but PW15 is saying that when
there is a oral dying declaration which was not challenged by the defense
which was
oral
not
dying declaration when he was
no
not
that
fired.
PW15 has stated about the dying declaration PW15
that was not challenged also.
We'll see that so one is dying declaration and what else
leading to discovery that kerosene jar and the matchbox
by the appellant
Man.
Okay, two is leading to discovery of kerosene jar.
And there was quarrel between them frequently. That is also evidence as motive.
Frequent quarrel motive.
Quarrel with both the persons, Miller, regarding that motive with the first wife and the second wife.
As well as with the husband.
So, what is the statement of that PW7? The
PW7 has not whispered anything, Miller.
Because she was present from the very beginning.
Yes, sir.
So let us see that evidence first, then we'll go to PW15.
Page 36. The accused in the dock is my mother. Lakshmi Badaik is my Sanoma, who used to stay at Jirpani with my mother. My Sanoma used to stay at Tungurpalli, Chokda. My father stayed with Lakshmi most of the time. He used to occasionally visit us. About 6 months back, on 27th, my father and Sanoma had come to our house. They stayed in our house that night. I went to bed at about 9:30 p.m. Hearing halla and commotion, I woke up at about 1 a.m. I found my father badly burnt and he had no clothes on. Lakshmi was near him and I did not find my mother.
Lakshmi means?
Lakshmi means the
PW
informant.
PW15.
PW.
Okay. Hmm.
Lakshmi was near him and didn't find my mother. The accused anywhere near. I covered my father by means of a blanket and in desperation rushed to the house of my Bodama, PW6 million. Sorry, mother of PW6 Archana. I went to PW3. We took my father in his auto to the Sahoo clinic. It was closed. Then we went to CWCS hospital. The doctor opined the injuries to be serious and asked us to take him to IGH. We went to the IGH and got him admitted there. And then cross-examination. Our house is 2 rooms. I was sleeping on the first room used as kitchen. My father and Lakshmi were sleeping in inner room. My mother was sleeping outside. I have not seen how my father got burnt. It is a fact that I have not stated before the police that I had gone to Taramani and had informed her about the burning of my father.
Taramani is the mother of the deceased.
No. But the Bodmar of woman Bhai with Archana's son.
PW6.
PW6.
Taramani is PW8.
Taramani is PW8.
No.
He has not supported my lord.
All right. Then
it is a fact that I have stated before the police that I had gone to Taramani and had informed her about the burning of my father. We were sleeping in a dark said room. I shouted, seeing my father with burns. Hearing my shout, my mother came from outside. She put water on my father. My mother was weeping, sitting outside of her house. Mother means the appellant here. Of her house. When I woke up, I found my father in the room I was sleeping. I have no knowledge how my father received burning it.
Okay, that means so far as this witness is concerned, he has not been declared hostile, but he has stated that it is rather the informant who was present with the deceased, sleeping in that.
For a moment, my lord, I want to draw your lordship's attention, my lord, to the spot map, my lord, because the house is the
page number?
Page 59, my lord.
Yes.
Your lordship, kindly see the portion given in the lower portion, my lord. There are three. The portion 3, my lord, is the veranda where the present appellant was sleeping, my lord.
Along with this PW?
No, along with Binika, my lord, with her daughter. She was not inside the house, my lord.
Okay.
No, she was in the veranda, but son was there outside.
Son was there, my lords, in 2.
In 2.
What
and kitchen,
3.
kitchen. Yes, my lord.
In 3, appellant along with.
No, in 1. In 1 appellant with the present informant was sleeping.
एक number room रे
अच्छा एकटा bedroom.
एक room टा होची bedroom, right?
Bedroom.
सेठी deceased थिला आउ से जो
Lakshmi Bade, PW15
थिला.
Second wife.
एक number आउ 2 number रे थिला किए? वो माने ये जो PW7.
PW7.
अच्छा बाटटा अछि सेई गोटिए बाटो जिबाकू को रूम भीतर देई. बाकी रहला बारंडा रे सोइथिले. PW नंबर रे सोइथिले appellant सोइथिला
ता जियो बिनिका सोइथिला.
जियो examine हे.
Now, my lord, the statement of the PW7. Now, my lord, I am showing the statement of the PW7. From the very beginning, saying that my mother was not there, my lord, when I woke up and found my father was standing in front of the door.
At 1 a.m. in the night.
What a 1 a.m. night. When I shouted, my mother came from outside.
Just a minute. Outre podile seta. I went to the bed at 9:30 to outre podam.
I went to the bed at 9:30 p.m. Hearing holla and commotion, I woke up at 1 a.m. I found my father badly burnt and he had no clothes on. Lakshmi was near him. Lakshmi PW15. And I did not find my mother. The accused anywhere near. I covered my father by means of a blanket and in desperation rushed to the house of my Bodoma, PW6 minute. I went to PW3. We took father to his auto. Then that portion is there in cross examination. No, that has come in cross examination. Then we went to CWC hospital. The doctor opined the injuries to be serious and asked us to take him to IGH. We went to the IGH and got him admitted there. Our house is 2 rooms. I was sleeping on the first room used as kitchen. My father and Lakshmi were sleeping in inner house. My mother was sleeping outside. I have not seen how my father got burned. It is a fact that I have not stated before the police that I had gone to Taramani and had informed her about the burning of my father. We were sleeping in a dark shade room. I shouted seeing my father with burns. Hearing my shout, my mother came from outside. She put water on my father. My mother was weeping sitting outside of her house. When I woke up, I found my father in the room I was sleeping in. I have no knowledge how my father received burning injury.
Okay. Then
my lord, kindly come to PW3.
just a minute.
PW7.
Mr. Tripathi, please wait. He is placing his own case first. We'll hear you afterwards.
Madam.
So you come to PW6 and PW8.
Madam. Prior to that, I am also showing PW3, the auto rickshaw driver, who are taken.
No, we'll go to that.
Yes,
Let
yes.
us, the person who
PW6.
are near there, we first come to PW6.
PW6 Archana Mundari. The deceased is the younger brother of my father. The accused in the dock was his wife.
This is the younger brother of my father. Okay, Kaka.
The accused in the dock was his wife. The informant Lakshmi was the second wife of the deceased, Chutki. About
Lakshmi means PW15.
PW15. About 6 months back, during the night or 27th at about 12:30 a.m., my mother told me that the accused had burned the deceased. I went to his house. She was sitting shrouded with some clothes. He was pleading for his life. He was immediately taken to the hospital. We later learned that he had expired.
My mother told means
that PW7 से ता माँ ना कही चे क्या से जो तारामणि.
Taramani is PW8 na? You कहला ना in the at about 12:30. My mother told me that accused has burnt the deceased. This my mother is PW8.
PW8.
Okay.
Taram.
So come to PW8 then. Acha, cross examination.
Lakshmi had come to our house around midnight and had called my mother. I was asleep at that time. I have not heard what she told my mother. Lakshmi was staying at Jagda in the house constructed by Mangal. She was not coming to Jirpani. I have no knowledge regarding the death of Mangal.
So this information, whatever PW8 got, it was from PW15. All right, come to PW8 then. Then we'll go to other evidence.
The deceased Mangal, PW8 The deceased Mangal was the younger brother of my husband. The accused was his wife, so was Lakshmi. About 7 months back around midnight, Lakshmi came and told me that the accused had set fire to Mangal. I went to their house and found Mangal badly burned. He was pleading for his life but couldn't tell anything else. Thereafter, he was taken to the hospital in an auto of PW3. When I went to their house, the accused was there. Later, I learned that Mangal had expired. When Lakshmi came to me, PW6, my daughter was asleep. I cannot say how the deceased got fire. Lakshmi used to stay at Jagda. It is not a fact that she never came to Jirpan.
Okay, then you are placing that evidence of PW3.
The auto rickshaw driver.
Auto rickshaw driver who carried the deceased in that injured condition to the hospital.
To that hospital.
Okay. Please place.
I know the informant Lakshmi Bodai. I know the accused in the dock. I also know the deceased. During the night 27-28th of February 2011 at about 1:15 a.m., I woke up on being called by C.K. Mundari, PW7, son of the deceased. He told me that his father had received burn injuries and sought for help. I took the injured, accompanied the informant, his son Siki and daughter Binita to the Sahoo clinic at Chitpani. There was none there. We went to the Milord here. Milord, he has stated that Milord, he was with the deceased son Siki and daughter was there in the auto. There was none there. We went to the CWC hospital at Jogda. The doctor available told us that the condition was serious and advised us to take to IGH. The injured was semi-conscious. We went to the IGH and Mangal Mundari was admitted to the hospital. After that, Siki told me that his mother, the accused, had set the injured on fire. After some time, I came back. On 28 to 2011, I was not at home. On 29 to 2011, I learned that Mangala Mundari had expired. That day, the police seized half-burnt blanket, half-burnt mattress, and half-burnt putty in my presence from the house of the deceased. The seizure list, so on, so on, so on. Now, I'm not cross-examination. The informant Lakshmi residing at Tungurupalli at Jogda, about 2 kilometers away from the house of the accused. The accused and Mangal, the deceased, used to reside at Chitpani. Siki didn't tell me how Mangal received burn injuries when he called me at about 1:15 a.m. Mangal has not told me anything as to how he received the burn injury. When I took him from their house, he was conscious. It is not a fact that the contents of the seizure list was read out.
Sikiটা কি?
Siki PW7.
PW7 আছে।
ସେ ଚିଫ୍ ରେ କହିଥିଲା ଯେ ସିକି ମତେ କହିଛି ବୋଲି ଇଏ କଲା, but କ୍ରସ୍ ରେ ମନା କଲା ଯେ ସିକି
ଆଚ୍ଛା, now we will come.
ସେ ମନା କଲେ
Siki didn't tell me how Mangal received burn injury when he called.
1:15 ସେ ଯୋଉ ରାତିରେ ସେ କହିନି, after admitting in hospital he has told. That is in the examination in chief. Cross examination କହିଛି ସେ ରାତିରେ ସେ ମତେ କହିନ।
And also the deceased Millers, at that time he was conscious, he also didn't tell anything about the incident.
Then PW15.
15. Page 51. I am the informant in this case. The deceased Mangal Mundari was my husband. I know the accused in the talk. My husband had married to accused. Subsequent to his marriage with her, he had married me. I used to reside at Jogda. The accused used to live at Jitpani. Mangal Mundari lived at either of the places, and the accused and I were on visiting terms to each other's houses. On 26/7 in 2011, I had gone to Jitpani to the house of the accused on being called by the deceased. After dinner, we slept. The house had 2 rooms. The accused slept on the front veranda. The accused son Siki, PW7, slept in the entrance room. My husband and myself slept in the inner room.
Same thing which is stated by PW7. So the position is same.
Position is same.
Okay.
At about 12 midnight, I woke up to find Sunita in our home. Sunita means the appellant.
Appellant.
I got up and went out to ace myself. From outside, I heard the shouting of the deceased. I rushed in and found the deceased with severe burn injuries, standing naked at the door and shouting for help. The accused had come out to the place where she slept and was having a satisfying smile. My husband told that the accused poured kerosene on him and had set him on fire by striking a matchstick. The room where we slept was dark. I wrapped a chadar around the burning deceased. I took him to one Dr. Sahoo's clinic at Chirpani, but he denied to entertain him. Then I took him to the CWC hospital Chirpani, the same auto rickshaw. He was also not treated there. I brought him to IGH. He was treated there. He died during treatment at IGH on 28/6/2010 afternoon. Following day, I got a report written by PW4 and lost the same at Chirpani PS. The report was written as per my instruction. I put my LTA after understanding the contents. Exhibit 3 is the said report. Following day, the police conducted inquest in my presence. I do not have any document regarding marriage with the deceased. It is a fact that we didn't have any institutional marriage or a social one. I used to reside Tungurtola, Jogda. It is not a fact that house belonged to my deceased first husband. It is not a fact that the deceased Mangala Mundari was not my husband and I did not have any relationship with him. It is not a fact that I was never in visiting terms with the household of Mangal and the accused at Chitpani. It is not a fact that I have not gone to the house of the accused at Chitpani on 27/6/2011. It is not a fact that I have not stayed in her house during that night, and that there was no occasion for me to get up during the night. It is not a fact that no such occurrence had taken place, and that I am deposing false.
Okay. The evidence of the doctor that it is a case of burn injury.
Yes, my lord. Doctor has
Any dying declaration was recorded during the treatment at the hospital?
no.
No. So who is the doctor
Doctor
conducted?
PW 13, page 46. On 36 2011, I was in my present post. That day at 11:30 a.m. on police requisition, I conducted the postmortem of Mangal Mundari, son of Jangal Mundari, and found the deceased had received burn injuries on the whole of the face. 70% of the burn injury covering the anterior part of the neck leading up to the nape. 1 cm strip of the skin on the nape is intact. Burn injury on the Burn injury on the anterior side of the whole of the trunk, both upper limbs, perineum, genitals, both lower limbs except the sole of the feet. 4. There were also patchy involvement of the skins on the scapular area, both buttocks. The burn injuries were such that the flow of inflammable liquid on both the sides of trunk and limbs had gradually trapped backwards. Age of the wounds was approximately within few hours of 24 hours of death. The death had occurred more than 12 hours prior to the PM examinations. Cause of death was due to extensive burn injury amounting to 70 to 78% burns. I preserved samples of blood, nail clippings, clap hairs, and burn skins in 4 separate plastic jars labeled and sealed by me. I handed over the same to the escorting constable after the PM examination. The viscera was collected and sent for the SD hospital Panpost. Exhibit 11 is my report cross-examination. It is not a fact that the burn injuries on the deceased could have been possible by an external fire in which the house had burned. It is not a fact that a person in deep sleep, either due to intoxication or otherwise, would receive such injuries in case the house of the place where she slept got fired. It is not a fact that a consumed alcohol is inflammable. The intestine did not emit any smell of liquor.
So what is the spot visit report of the IO? Because the occurrence in question, if it has taken place in the first room, which is the bedroom, and there the kerosene was poured and she was set fire.
Regarding kerosene, doctor is completely silent. The smell of kerosene.
Doctor has not stated any kerosene smell was coming.
My lord, PW 14 is the first IO, and PW 12 is the second IO. And I am placing the depositions of PW 14, the first IO.
Because the time gap is very small. କାରଣ ସିଏ ଏଠି କହୁଛି ଯେ ମୁଁ ପରିଶ୍ରା କରିବାକୁ ଯାଇଥିଲି ତାରି ଭିତରେ ଘଟଣା ହେଇଛି.
And when he woke up, he found that appellant was present there.
No. Question is suspicion against 2 persons. It may be the appellant, it may be that PW15.
If PW15 is the culprit, my lord, he should not have tried to save his life. If PW15 would have been the culprit, my lord, he should not try to save his life.
No, this lady has also tried to save the life. PW7
he was not at all present anywhere, my lord. She has not gone to the hospital.
No, gone to the hospital, auto rickshaw ଦି ଜଣ ବସିକି ନେଲେ.
That he has taken the plea also, but
no. ଗୋଟେ ସାଇଡ କୁ ଆପଣ ଦେଖନ୍ତୁ ଆପଣ ଯୋଉ କହୁଛନ୍ତି ନା ସିଏ ସେଭ୍ କଲାନି ଆପଣ ଯୋଉ ଏଭିଡେନ୍ସ ଟା
unchallenged kerosene jar and the matchbox the kerosene jar and matchbox was recovered from this appellant man. ସେଟା ଗୋଟେ ଜାଗାରେ ରଖା ହେଇଥିଲା PW14 station.
No, we'll come to that. That can be. So you made a submission that she has not tried to save her husband's life, which is a conduct against, but
Except the son in PW7 at the stage of cross-examination, no evidence has come
How to
that
gain
he has saved.
uh,
He tried to save the
he has
deceased.
stated in the chief examination. This
Yes,
PW7.
except PW7, nobody has stated.
So, that is your witness.
Hmm.
Your witness has stated. So, have you declared him hostile? That so that evidence remains that this lady also tried to save her husband by pouring water on her body, on his body. The evidence was, hearing my shout, my mother means appellant, came from outside. She put water on my father, and my mother was weeping, sitting outside of her house. So the reaction would be different. Cannot say that this is the reaction somebody would do. So jane lady hueto तार करेज थिला सी ताकू तार हस्बैंड को accompany करी गला ऑटो रिक्शा रे आउ जने लेडी रो हुएत करेज नथिबो सी बसी कांदीबो स्वामीर अवस्था
And
देखी
in that circumstance, also both of them, the son as well as the PW15, both of them disclosed that she has set fire on her husband, her father. PW7
dispute is not that how the deceased died. Okay, deceased had died out of burn injuries. So question is, and the occurrence took place inside the bedroom where the PW15 was sleeping.
Yes, sir.
Right?
Yes.
And adjacent room, only one door is there. You see the adjacent room, the son was sleeping. And on the veranda, this appellant was sleeping along with her daughter. Okay.
Right.
So
But PW7
the evidence only that might dying declaration which is stated is only relating to the evidence of the
both the declaration oral last scene that was not challenged by the defense.
Last scene to ଆପଣଙ୍କର PW15 ବି last scene ଥିଲା ନା
Yes,
rather she was sleeping with her. ଆପଣ ଯୋଉ circumstance କୁ use କରିବାକୁ ଚାହୁଁଛନ୍ତି against a, that is also against you, except if you exclude that dying declaration, every other thing is against you also. Last scene is there, your presence with the husband is there, and conduct, if you are saying that conduct is same, he is tried to save, son tried to save, this man also, this lady also tried to save.
Well, at PW7 categorically stated that my father being set fire by the appellant to the PW3, your lordship. PW3 ku jaiki kahichi PW7.
Kiye?
PW7, PW3 statement, my lord, kindly have it.
PW3.
Yes, your lordship. And similarly, PW15.
Just no, don't rush. If you are advancing a point, stick to it and prove it.
My lord, the injured was second.
Which paragraph you are
second paragraph?
Yes.
The injured was semi-conscious. We went to the IGH and Mangal Mundri was admitted to the hospital. After that, Siki told me that his mother.
Who is Siki? PW?
7.
Yes.
Told me that his mother, the present appellant, had set the injured on fire.
Haji PW7 stated so.
Yes, ma'am. He has stated, but it was not challenged.
So, somebody, it's a hearsay evidence.
Yes, that is.
Is it not a hearsay evidence? So, PW7 told before me that that the accused set fire to the injured. He is not himself an eyewitness. PW7 is he a witness?
No.
So, what is his statement before PW3? PW7 told me that his mother, the accused, had set fire. PW7 statement is otherwise. You have not declared him hostile, and he has not stated even before that to have made any such disclosure before PW3. So, two things are against such a statement. Number one, that PW7 has not stated to have disclosed before PW3, and PW3 statement is otherwise. He has not stated anything against his mother, means the appellant. So how this evidence which is deposed to by PW3, can we exclude the evidence of PW7 totally, who has not been declared as witness hostile, and rely on this evidence of PW3 that it is the PW7 who has made the disclosure, when the PW7 himself has not stated to have made any disclosure? Okay.
Second thing, my lord, PW15 had disclosed before PW8. That is also there. PW15 disclosed it before PW8.
What he disclosed?
About midnight, Lakshmi came and told me that accused had set fire to Mangal. I went to their house and found Mangal
So it is the same kind of statement that PW3 is giving, PW8 is also giving in the same manner. Now, the statement that PW3 had given has not been consistently carried by him in the cross-examination, because in the cross-examination he is saying, Siki did not tell me Mangal received burn injuries.
During the night, my lord.
Huh.
But
Okay,
after, he has stated in his cross-examination in chief that after admission of in the hospital, he has stated this thing. I'm reading again, my lordship.
At 1:30 a.m. At about 1:30 a.m.
Right.
Mangal has not told me anything as to how received
At
the
that
burn.
time, immediately taku kahini, but subsequently he has stated. That period he has not.
At the time when he called, he had not told.
ଆପଣଙ୍କର ହିୟର୍ସ ଏଭିଡେନ୍ସ ର ଲିଙ୍କ ଟା ଏଷ୍ଟାବ୍ଲିଶ କରିବାକୁ ହେଲେ ଜଣଙ୍କର ପ୍ରଥମ କଥା ନଲେଜ ଥିବା ଦରକାର। ଏଠି ଆପଣଙ୍କର ନଲେଜ ହଉଛି PW7 PW7 ଯଦି ନିଜେ କହୁନି ତାହେଲେ ସିଏ ଅନ୍ୟ ପାଖରେ ଡିସକ୍ଲୋଜର କହିଲେ ତାର ଏଭିଡେନ୍ସିଆରୀ ଭ୍ୟାଲ୍ୟୁ କଣ ହବ?
But my PW15 has stated categorically.
ହଁ
PW15 has stated.
ଆମେ ଗୋଟେ ଆପଣ ଯୋଉ ହାର୍ଟ କଲେ ନା ପ୍ରଥମେ କହିଲେ ତା ପାଖରେ କହିଛି, ଆମେ ଗୋଟେ ଗୋଟେ କୁ ଧରୁଛୁ। ତାପରେ my esteemed brother has pointed out in the cross examination also in PW3, Siki did not tell me how Mangal received burn injury when he called me at 1:15. Hela? Mangal had not told me anything how he received burn injury when we took him Swansu. So ଏଇ ଯୋଉ ଆପଣ କହୁଛନ୍ତି ଯେ ତାକୁ ଯେତେବେଳେ ଡାକିବାକୁ ଗଲା, ଆମେ ଯଦି ଏ ତିନି ଏଭିଡେନ୍ସ ଟାକୁ ଦେଖିବା ଚିଫ ଆଉ କ୍ରସ କୁ ମିଶେଇକିନି, ତାକୁ ଯେତେବେଳେ ଡାକିବାକୁ ଗଲା ସେତେବେଳେ PW7 କିଛି କହିନଥିଲା ଯେ ତା ବାପା କେମିତି ଇଞ୍ଜୁରି ରିସିଭ କଲା। ଗାଡିରେ ଯେତେବେଳେ ଯାଇଛନ୍ତି ସେତେବେଳେ ମଧ୍ୟ ତା ପାଖରେ କିଛି ଡିସକ୍ଲୋଜର ନାହିଁ, even if deceased ମଧ୍ୟ କିଛି ଡିସକ୍ଲୋଜ କରୁନି। Number one, then after admission your case is that PW7 made such a disclosure, right? But that is not being corroborated by PW7 who has not been declared hostile. So how this here's evidence can be utilized against the accused in view of these hurdles?
That can be, but PW15 has stated. And
PW15.
My lord, the informant.
Some more evidence was required here, because if at all it is accepted that yes, she was present in the night and sleeping with her daughter, and the son is saying that I did not find my mother and she came only after his outage. So the proximity of the incident happening, as said by PW15, that she saw when she was going to ease and heard this sound. So the proximate time is so short. With that, the appellant came, poured kerosene, lit the match stick, and kept the kerosene box and all that in a place. So what is the time when she had gone to ease?
What my brother is pointing out, appellant to ତା ପାଖରେ ତ knowledge ନଥିବ ନା
ହୁଁ
ଏଇ particular ସମୟରେ PW15 କୁ ପରିସ୍ରା ମାରିବ ସିଏ ଉଠିକିନି ଯିବ
ଯିବ।
ମୁଁ ସେଣୁ ପ୍ରସ୍ତୁତ ହେଇଥିବି ମୁଁ is it possible? No. ଦ୍ୱିତୀୟ କଥା ସିଏ ଜଣକ ଘର ଦେଇକିନି ଯାଉଛି ଯୋଉ ଘରେ ତା ପୁଅ ଶୋଇଛି ସେକେଣ୍ଡ ରୁମ ଟାରେ ପୁଅ ଶୋଇଛି ବାରାଣ୍ଡାରେ ଶୋଇଛି ଇଏ ତ ସେ ସେଠିକି ପଶିବ ତାପରେ ଆଉ ଗୋଟେ ବାଟ ଦେଇକିନି ପଶିବ ଇଏ ଘରକୁ ହେଲା ତେଣୁ
confessional statement से जो करीची although it is not relevant से ଜାଗାରେ ସିଏ admitted ଯେ ମୁଁ ସେ ଭିତରକୁ ଯାଇଥିଲି I want to kill both of them but ସିଏ ଉଠି ପଡିଲା
ହୁଁ
ସେ ବାହାରକୁ ଗଲା ପରେ I set fire kerosene to only my husband.
no that is rather another unbelievable story
That is
ଯଦି
very
ସେଇଆ ହେଇଥାନ୍ତା କିରୋସିନ ନେଇକି ଯାଇଥାନ୍ତା ଇଏ ତାକୁ ଉଠି ପଡିଲା ସିଏ ତା ସ୍ୱାମୀ କି ଛାଡିକିନି ଚାଲି ଯାଇଥାନ୍ତା ଯେ ନାଇଁ ନାଇଁ ତୁ ପୋଡ ମୁଁ ଯାଉଛି ବାହାରକୁ ପରିସ୍ରା କରିବାକୁ
that is their celebration.
how can it be believable?
No, not believable.
No.
But that is
See,
No, that is how some more evidence was required.
suspicious also.
and so far the recovery part is minor that was kept
What
in
is that?
place.
Recovery is what? Jerkin.
Jerkin,
Recovery means
that
by
kerosene
27.
jar.
27.
Yes,
Yes.
yes.
We don't understand one thing. The 27 Evidence Act is being brought to application without giving a foundation of that. The first question remains with the investigating agency that he searched the house, did not find any of this thing, and it is only with the at the instance of the appellant that they could see it.
Right.
So the place of concealment would be such that it would not come to the notice of the investigating agency or anybody in the inmates of the house to see it. Whether that part of the evidence comes. 27 comes only thereafter
Thereafter.
when it is not found otherwise than the knowledge of the person who has concealed it. Otherwise, the investigation is no meaning. They made a house search after the burn injury. They made a house search. They did not get any clue of it. And only at the instance of the appellant that we could know it. So that is very important. So 27 in every case. So
What is the this kerosene jar which or bottle? What is that?
Yeah.
Jerkin.
Jarkin. Jarkin ने आपण evidence आछि ता देरे 300 ml kerosene थिला आसुना दी PW
14.
page 48
Right.
evidence of PW 14
The leprosy.
आपण गोटे किरोसिन जार प्रथम होची तार से जार्किन केते धरी पारिबो कारण 300 तादेरे थिला 300 मिलीलीटर्स थिला ओके तेणु से केते तादेरु खर्च होईची नंबर 1 नंबर 2 जणे जदी जार्किन नु ढाळीला एक्जाक्टली तो स्वामी ऊपर ढाळीबनी किछि हुए तो पड़ी जाईथिबो सेई जो बेड ऊपर पड़ीथिबो ताले आपण बेड सीज करथिबे ताले बेड रु आथर तो डॉक्टर पे एविडेंस आसिलानी जे किरोसिन मिलिला बेली ता किरोसिन स्मेल किछि मिलिला बेली तेणु जो बेड रे स्वामी सोई थिले जो इंसिडेंट आस्तिला से बेड को सीज करिकिनी देखिले कि किरो कौन मिलला
Chemical examination report is there.
what is that
Page 58.
58.
Page 56 is the seizure. 50 is the report.
Kerosene detected in the exhibits mark ABC.
just a minute एटा कोन
एटा होची मेला
It wearing apparel and matchbox. Having
wait एटा हला
56 page.
page 56 रे portion of the burnt apparels and matchbox having mastic labeled as so wearing apparels of the victim collected by the scientific officer marked as A. तामने एटा होची deceased
Right.
okay सेठुरु मिलिला किरोसिन दुई रे होची
बॉन्ड ब्लैंकेट
बॉन ब्लैंकेट
बॉन्ड ब्लैंकेट सेठुरु मिलिला किरोसिन सीटा मिलिला होची कोन प्लास्टिक
Plastic jerkin.
जार्किन सेठुरु मिलिला किरोसिन तेणु एई तीनटार किरोसिन आसीगला ठीक अछि ताले किरोसिन even if the PM doctor has not found any kerosene smell but from the wearing apparels of the deceased, then the bed where he was sleeping, blanket ସେଟାକୁ ସେଥିରୁ ମିଳିଲା ଏବଂ ସେ ଇଏରୁ ଏଗୁଡାକ ସବୁ କିରୋସିନ ଆସିଲା but again all these things which have been stated that since this case is based on circumstantial evidence ଆଉ ଖାଲି dying declaration ଟା କହୁଛି ଗୋଟେ ଏଇ witness ଯାହା ଉପରେ suspicion ମଧ୍ୟ ରହୁଛି
immediately she has gone and disclosed it before PW8 also.
ହୁଁ
Immediately after that occurrence, she went to PW8 and told it.
no
Here
So
there is
yes,
a
that is
my
also
lord,
yes.
my lord, here there is a contradiction, my lord. PW15, my lord, in her deposition had never stated that, my lord, she had been to the PW6 or PW8, my lord.
ସେ କହୁଛି କି
ନାଇଁ ଆଜ୍ଞା
ଆଉ କହିନି ଆଉ
rather
କଣ?
PW7 stated, my lord. She had been to the house of PW8.
ଦେଖିଲେ PW15 କହୁଛି ମୁଁ ଯାଇକି PW8 କୁ disclose କରିଥିଲି
ନାଇଁ no here.
So this link is very important. This is very important. 7 is saying.
PW7 is.
7 ତ ଗୋଟେ ଟୋଟାଲ ଡିଫରେଣ୍ଟ
So the
ପିକ୍ଚର ଆଣି
PW6 ସେ PW6 ଘରକୁ ଗଲା 8 ଘରକୁ ଗଲା ତାଙ୍କୁ ଡାକିକି ଆଣିଲା
କିଏ କହୁଛି ଆସି ତାକୁ PW15 disclose କଲା PW8
PW8.
PW6 and PW8 both
just
of
a minute.
PW6 कौची PW8 disclosed me. PW8 saying that PW15 has disclosed.
also at about 7 Lakshmi came. Lakshmi means also PW15
PW15
acha this is not corroborated by PW15 itself
Mal.
तामाने आउ थरे से जदि चीफ टा में पढ़िबा 8 नंबर रो deceased मंगल Swanso accused was his wife so also Lakshmi 7 months
around midnight
Swanso रे
Lakshmi came
लक्ष्मी आसिला एवं मते कहिला जे
accused had said
accused
that.
मंगल को पोड़ी देइछि तापरे एया सुनिकिनी मु तांको घर को गली एवं सेठी देखिली मंगल पोड़ा अवस्था रे पड़तला हला एया जदि हला but information has been who has stated that he intimated to PW8
PW7 Mal.
PW7 PW7 कोडी कोची intimation देला
My lord chief your lordship can
हां चीफ रे
Mal.
कोडा लाइन
Your lordship, my lord, 6 lines from the bottom, my lord. I'm reading. I covered my father by means of blanket and in desperation rushed to the house of my Bodoma.
बड़मा माने होची तारा
Tara, my lord. Tara alias Bodamani, mother of PW6 Archana.
अच्छा अच्छा वो बड़मा होची PW8
PW8.
ता माने इंफॉर्मेशन जो देइथिला ये तो PW7 देइथिला आ PW15 कोड देला ताकू आपण रिलाय करचंदी सेटा ऊपर तेणु evidence of PW8 that she got the information from PW15 that the appellant killed or set fire to the deceased is completely contradictory because from evidence of PW7 it appears that it is PW7 who gave the information to PW8 and not only that PW15 has not stated that she went and got the gave the information so ये जो link what my esteemed brother is pointing out link टा miss କରୁଛି ଆପଣଙ୍କର case ରେ ଯେ ଆପଣ ଯୋଉ evidence ଟାକୁ rely କରିବାକୁ ଚାହୁଁଛନ୍ତି ଯେ ସିଏ ତାର conduct ହଉଛି ଯେ ସିଏ ଯାଇକି immediately ଘଟଣା ପରେ PW8 ପାଖରେ disclose କଲା ସେଇ evidence ଉପରେ ଆମେ ଯଦି ତର୍ଜମା କରିବା ତାହେଲେ ଆମେ ଦେଖିବା ଯେ କଣ୍ଟ୍ରାଡିକ୍ଟୋରୀ ଏଭିଡେନ୍ସ ଆସୁଛି ଯେ ନାଇଁ ଇନଫ୍ୟାକ୍ଟ PW15 ହିଁ ଯାଇନି ତାକୁ ଖବର ଦବାକୁ PW8 କୁ. It is PW7 who had gone and gave information, and that is the evidence of PW7. And even PW15 has not also stated that I went and to the house of PW8 and gave information that the appellant killed has set fire to the. So if that is then gone, then only thing remains is the dying declaration, oral dying declaration stated to have been made by this, and that is stated by a person whose against whom also suspicion arises. अच्छा पूरा टोटल डार्कनेस थिला बेली कि गोटे कहूची से जगह रे
PW7
PW7
we are sleeping in a dark room in a cross
कोटा
examination in his cross examination
Hmm.
sixth line from the bottom.
6th line from the bottom.
Hmm.
We are sleeping in a dark room. अच्छा
Dark shade room my lord, पर ऊपर shade
the doubt posed by my senior brother that why she did not accompany to the hospital has been answered in the
313
statement.
Yes,
there
There
was
was
no
no
yes.
seat in the
सीट ऑटो रे जगह
नहीं obviously गोटे टेम्पोरी एमान तीन जण ऑलरेडी हेलेनी
Yes.
डिसीट होची चारि
सी हैज आंसर्ड
काई कोठी गेले
para
para
question 11
स्टेटमेंट में स्टेटमेंट
States
पेज 25 में
हां टेम्पोरी जगह नथिला ठीक अछि
क्वेश्चन 11
टेम्पोरे किए किए गले से कहूची PW3 होची टेम्पो ड्राइवर तो
PW4 and 15 गले
हाँ,
PW3 4
PW4 PW15 and the deceased
भाई
ପଛପଟେ ବସିଲେ ଇଏ ଚଲେଇଲା ସେ ଠିକ କହୁଛି ଆଉ ଜାଗା ନଥିଲା ତେଣୁ ଆପଣ ୟୁଟିଲାଇଜ କରିବାକୁ ଚାହୁଁଛନ୍ତି ସେ ଗଲାନି ତେଣୁ ତା
That's
କଣ୍ଡକ୍ଟ
the
ହଉଛି
explain.
suspicious. He was arrested from the spot house also.
Well,
He had not tried to abscond. No. He was found crying. That is the evidence. Not accompanied because he has explained that I not wrong.
but the jerkin was found from a Itagoda ପଛପଟୁ ମିଳିଛି.
Mound of bricks.
Yes.
You 534. Who are the witnesses to that jerkin?
PW5 and
five.
PW14 your lord.
14.
My lord, I am.
IO. You stated PW5 has stated that jerkin contained 20 to 30 ml of kerosene, and that jerkins of that type are available in open market, and it's a common household.
20 to 30 ml means there is nothing. Remnants is only there.
PW14 says 300.
That is
300.
300 is a substantial amount.
300 substantial amount.
So what is the extent? Oh, no.
Huh.
See, 500 ml is
Yes, the total there.
500 ml, and out of that 200 ml has been used, and rest it is not there. So all these things are appearing.
You see, somebody would, if he was sleeping, there was nobody to prevent him even to pour the entire
Yes.
kerosene. So he has just used a little, and then he must have tried also to set fire. So so
Jerkin the size ଟା ତ ନାହିଁ
ସେଟା
ନାଇଁ,
ବି ନାହିଁ।
ବଡଟା
ସେଟା ବି
ଯଦି
ନାହିଁ।
ହେଇଥିବ ପକେଇଲା ବେଳକୁ ରିମେନ୍ ରହିଲା ବେଳକୁ 300 ml ରହିଯିବ ଯଦି ବଡ ଜାର୍କିନ୍ ହେଇଥିବ।
And again,
That
as
we
was
cannot
being
do.
said,
Ah.
see the evidence of PW15. I woke up to find Sunita in our, no, the accused slept on the front veranda. The accused son such and such. My husband and myself slept. I woke up to find Sunita in our room, and I got up and went. That means by the time she got up, she woke up, she has seen Sunita present. All right. Now, from outside, I heard the shouting of the deceased. I rushed in and found deceased with severe burn injuries, standing naked at the door and shouting for help. The accused had come out to the place where she slept, means on the veranda. That means she is coming out. So the proximate time by which the witness 15 is rushing to the room, she could find that the deceased has already come. Accused is standing. So if we say, then the jerkin should be with her. If she is coming out,
not stated to have seen the jerkin in the hands of the,
because there is nothing. What is the time gap?
because thereafter he will go and keep that jerkin.
Then again, she will come and stand there.
That time when he was seeing hearing that halla, my lord, might have that her intention is totally towards her husband. How she is burning, she might have not noticed that he was going with that jerkin. You know, so that might be possible.
No,
So some
And
evidence is required, so everything is might.
And second thing, my lord, so far doubting the integrity of the
what is the source of light in that bedroom when she went outside? Because the son has stated it was completely dark. So when you were considering the evidence of dying declaration, it was one of the requirement as per law to see that the deceased had scope to identify the culprit. ହେଲା ତେଣୁ it's all right. ତେଣୁ ଆପଣଙ୍କର ଲାଇଟ ର ସୋର୍ସ କଣ ସେ ଏଭିଡେନ୍ସ ବି ନାହିଁ କଣ ଆପଣଙ୍କର ଗୋଟେ ପୁଅ କହୁଛି ଟୋଟାଲ ଡାର୍କନେସ୍ ଥିଲା ଯୋଉଟା ବାହାରେ ଆପଣଙ୍କର ଏଭିଡେନ୍ସ ଯେ ଥିଲା ବେଡରୁମ ରେ ଲାଇଟ ଥିଲା କୋଉ ପ୍ରକାର ଲାଇଟ ଥିଲା ଯୋଉଟା କି ଏଗୁଡାକ ସବୁ ଏଭିଡେନ୍ସ କିଏ ଆଣିବ ପ୍ରସିକ୍ୟୁସନ ଆଣିବ ନା ଯେ ଯିଏ ଆସିଥିବ ସେ ପକେଇଲା ଫାୟାର କଲା ଗଲା ତାରି ଭିତରେ ଜଣେ ଆଇଡେଣ୍ଟିଫାଏ କରିବାର ଇଏ ଥିବା ଦରକାର ସୋର୍ସ ଅଫ ଲାଇଟ ମାନେ it's all right that because of the close relationship gesture ଆଉ ଇଏରୁ ମଧ୍ୟ ମାର୍କ ହେଇପାରିବ କିଛି ଇଏ ନାହିଁ but ଏଇ ଯୋଉ ଟାଇପ ର କେସ୍ ରେ as my brother pointed out that when you are ଯେତେବେଳେ ତାକୁ ଦେଖିଲା ବାହାରକୁ ଗଲା ଛିଡା ହେଇଛି ସେତେବେଳେ ତା ହାତରେ କୌଣସି ଜାର୍କିନ୍ ଥିବାର ଦେଖିନଥିଲା ହେଲା ଯେତେବେଳେ ଫେରିଲା ସେ ଜାର୍କିନ୍ ତା ହାତରେ ଥିଲା ବେଳେ କାରଣ ଟାଇମ ଗ୍ୟାପ ଟା ହଉଛି ବହୁତ ସର୍ଟ it is not it is just ସେଠି ୱାର୍ଡିଂ ହଉଛି ପରିସ୍ରା କରିବାକୁ ଯାଇଥିଲି एटा जाइनी जे लैट्रिन को यूज करिया कौन से अदर पर्पस रे तेणु टाइम गैप टा बहुत शॉर्ट थिगो तेणु तारी भितरे जदि आपण एविडेंस आनुनांती दैट ही इज हैविंग दैट jarkin with her and then
Some more amount of evidence was required to explain this portion.
And one more thing, my lord, but you kindly visualize see the second way. She has no strenuous relation with the husband, deceased, because that is why she is sleeping inside the room with the husband,
Hmm.
deceased.
Hmm.
And the appellant was sleeping outside.
Hmm.
Definitely, strenuous mind, there will be definitely a mind of
Yes, yes.
there.
What you are saying could be there. That could be there, but that cannot be the sole thing
again
on which you can go.
Yeah, no, that is done the sole thing, my lord, than the recovery part that jerkin was recovered from a place which was not seen to everybody. It was
ଇଟା ଗଦାରେ ତ ପଡିଥିଲା କଣ ତ ଲୁଚି ରଖିଥିଲା ନା କଣ
ଲୁଚେଇକି ରଖିଥିଲା
ଇଟା
ବୋଲି
ଇଟା ଗଦା ପକା ଆପଣ ପୁରା
ପଛକୁ ଅଛି।
ଆପଣ you see the
Mound of bricks.
Mine.
Mound.
Hey,
Eta gada
ତା
ଥିଲା
ଘର
ତ?
ପଛପଟେ mount of
So,
bricks
ସେ
would it
list
not come to the notice of the investigating agency if there is a search? Is there any such conclusion drawn? There, I made a search in and around the house, did not find any clue.
ଆପଣଙ୍କର ଯୋଉ ଏକ୍ସିବିଟ୍ 5 ଟା ଯଦି ଦେଖିବେ କଲମ ନମ୍ବର 4 ରେ ଲେଖା ହେଇଛି 4 ର ସି ରେ ଯୋଉଟା ପ୍ଲେସ୍ ଅଫ ସିଜିୟର ଏଟା ଲେଖା ହେଇଛି ସିଜ୍ ଫ୍ରମ୍ ଦି ବ୍ୟାକ୍ ସାଇଡ୍ ଅଫ୍ ଦି ସ୍ପଟ୍ ହାଉସ୍ ନିୟର ଦି ହିପ୍ ଅଫ ବ୍ରିକ୍ସ ଆଟ୍ ସୁଆଣ୍ଡସୋ ଜିରପାଣି ଯେ କାହା ଭିତରେ କି କଣ ଲୁଚେଇକିନି ରଖିଥିବା ସେମିତି କିଛି ନାହିଁ ତେଣୁ ବ୍ରିକ୍ ପାଖରେ ପଡିଥିଲା ଯୋଉଟା କି ସିଜ୍ ହେଲା
So giving recovery under section 27 is a very strong circumstance, no doubt about it. But at the same time, the evidence must be clinching to that effect.
is it not an open place?
Yes.
So what my brother is pointing out that it should be at such a place which could not have been otherwise discovered unless without the special knowledge of the person who has concealed the same. Then that kind of evidence is necessary to clinch an issue under section 27. ସମସ୍ତେ ଯଦି ଖୋଲାରେ ପଡିଥିବ ଇଏ କରିଥିବ ଯୋଉଠି କି ଆଇଓ ଖୋଜୁଛି ଇଏ ଚାରିଆଡେ ଖୋଜିଥିବ ହଁ ସ୍ମେଲ ପାଇଥିବ କୁଆଡେ ଗଲା କିରୋସିନ ହଁ
that was told by PW5 man that it was
କିଏ
concealed concealed in that brick.
How could she know?
She was witness to that.
No. How
that was told by the accused and they when they took the
30 ତାରିଖ ଦିନ ସକାଳେ ଏକ୍ୟୁଜ ତା ପାଖରେ କହିଲା ଯେ ମୁଁ ମାରି ଦେଇଛି ବୋଲି ଏଇଟା ତ ଏକ୍ସଟ୍ରା ଜୁଡିସିଆଲ ତା ପାଖରେ ବି ଅଛି
ନାଇଁ PW5 ର ଏଭିଡେନ୍ସ ଆପଣ ରିଲାଇ କରୁଛନ୍ତି ସେ କୋଉଠି କହିଥିଲା ଇଟା ଭିତରେ ଲୁଚିକିନି ରଖିଥିଲା
I'm reading that portion. She also told that kerosene was in a jerkin and she kept the jerrycan concealed by their side of a brick mount behind their house.
ସିଏ ପାଇଲା ଯେ ଏଇଟା କନସିଲ୍ଡ ଅବସ୍ଥାରେ ଥିଲା ବୋଲି କୋଉଠି କହିଛି
She told.
ଆରେ ସିଏ ଟୋଲ୍ଡ ଯେ ଆପଣ ଆସୁନାହାନ୍ତି କୋଉ ଅବସ୍ଥାରେ ପାଇଲା ତାପରେ ଆସୁନାହାନ୍ତି ତାପରେ କଣ ହେଲା she led the police party and myself to the place and gave recovery of the jerkin ସେ କୋଉଠି କହିଛି ଯେ ଆମେ ସେ ଖୋରି ଛାଡି କୋଉଠି ତା ଇଟା ଭିତରେ ଲୁଚେଇକିନି ରଖିଥିଲା ତାକୁ ବାହାର କରିକିନି ଦେଲା
and it was not visible.
That is
kind.
ଆଉ ଜେରିକେନ ର ଯୋଉ ପୋଜିସନ ସେ କହୁଛି 20-30 ml ଆପଣ କହିପାରିବେ ନାହିଁ ସେ କେମିତି କ୍ୱାଣ୍ଟିଟି ଟା କହିବ ଗାଁ ଲୋକଟା ସେମାନେ ଯୋଉମାନେ କି ଆଣନ୍ତି କିରୋସିନ ସେମାନେ ୟୁଜ କରନ୍ତି ସେମାନେ କହିପାରିବେନି 20-30 ml ଆଉ 200-300 ml ତା ଭିତରେ ପାର୍ଥକ୍ୟ ସେମାନେ ଡ୍ର କରିପାରିବେନି
rather they are more used to the kerosene they can say exact quantity so if it is 20-30 ml means nothing
କିଣିବାକୁ ଗଲା ପରେ ପୁରା ମାପ ହେଲେ କଣ ଏଟା କମ ଜଣା ପଡୁଛି ଆଉ ଏଟା ବୋଧେ ନୁହଁ ସେ କହିଦେବେ ନା ଆଖିରେ ତାଙ୍କର ଇଏରେ ମାପ ଥାଏ ହଁ ଧରି ନେଇକିନି କହିଦେବେ ଏତିକିଟା ଇଏରେ particularly when ଗୋଟେ 1 ଲିଟର ଇଏ ନେଇକିନି ଯାଉଛନ୍ତି ସେମାନେ 1 ଲିଟର ହାଫ ହେଲା ମାନେ ଇଏ ନା କମିଗଲା ମାନେ ଏଟା କମ ଜଣା ପଡୁଛି ଏତିକି ହବା କଥା ଶୁଣିକି ତ
my lord is also experienced they use it as medicine also.
Hmm?
In our area, they
Hmm.
used it as medicine also, kerosene.
No, so having kerosene
Huh?
is not the suspicious circumstance.
They
No,
use
no.
it as medicine.
We are not
Routine.
saying that having kerosene or seizure of kerosene itself is a suspicious circumstance. We don't say.
I want the quantity, my lord, because they use that for medicine purpose
Let it be.
in our
Let
area.
it be. They say that it was. So what was the quantity left as found in the
Yes.
jerry can?
Hmm.
The witness is saying 20 to 30 ml,
ml.
and the IO is saying
200
200.
to 300.
300 এবং এর মধ্যে সে
So
মেনশন
either of
করেছে
them is wrong. It cannot be 30 and 300. সেটা expected যে 30 ହେଇପାରେ. Reason being, if someone will pour kerosene, he or she will find that the entire kerosene is poured in. So it is 30. It cannot be 300. So either the witness is false or the IO is false. So that is how the evidence must be very clinching, because these are the only material basing on which your case stands.
Hmm. ଆଉ କଣ କହିବେ? So, anybody else is present?
ready ଅଛନ୍ତି. Thirty, 39.
No.
Two matters.
Interested by this. They're looking for Patnaik to do that. 38 and 39.
No, just a minute.
39, I will.
Please, just a minute. Mr. Counsel, it's a JCRLA.
Yes.
Sadhya Lakshmi Patnaik has been engaged by the court.
Court, yes.
So how she can give you to argue the matter?
On behalf of your.
I mean,
ଆପଣ ସେଟା ଛାଡି ଦିଅନ୍ତୁ 39 ଟା ଆପଣ ଅଛନ୍ତି ନା
39 I am is yours. You can proceed with 39.
39, it's a different. If it
39.
would have been a private brief, matter is different. Somebody may interest. But Sadhya Lakshmi Patnaik has been engaged by the court, right?
Yes.
So when she has been engaged, either she has to do it. If she has got any difficulty, she may bring it to the notice of the court so that another counsel can be. We may engage you. There is
You
no
also,
problem.
yes.
But she cannot say that you go. I am having difficulty. You. So she was engaged. JCRLA Sadhya Lakshmi Patnaik has been engaged by court. Yes, he has been engaged
I will inform her.
by the order of
If
the
she-
court, appointed by the legal aid counsel by the. So ask her, either she has to do the matter. If she has any difficulty, then she has to say to this court. Court may decide whether any other counsel. Okay. So be ready for this item number
39.
39. You can do it then. There you have been engaged by the. We'll take up this matter.
Here's something, madam.
This,
Yes.
you mentioned that this hearing had Mr. Vishwajit Naik, land counsel for the appellant, Mr. Rajesh Tripathi, land and additional standing counsel. Hearing is closed, judgment is reserved. Hello? Yes.
Well, item 45.
Hmm.
My name is there, man. Whether it's me or that Satyanarayana Mishra, I don't know.
Yeah, just a minute. You can see that. 45 CRL. It's a regular appeal. Correct. Appellant at flag A praying for engagement of advocate Satyana. It's a prisoner's petition has come. Prisoner petition ଆସିଲା ଯେ ମୁଁ ବର୍ତ୍ତମାନ ସରକାରୀ ସହାଂଶରେ ମୁଁ ସତ୍ୟନାରାୟଣ ମିଶ୍ରଙ୍କୁ ମୋର କେସ୍ ପରିଚାଳନା କରିବାକୁ ସହାଂଶ ମୁଁ ପରିବେଷଣ ତେଣୁ ଆପଣଙ୍କର
So
the
your SN Mishra 4. How can we know?
ନା ସେମାନେ ତ ଫର ଦଉନାହାନ୍ତି ନା।
ନାଇଁ ସେ ଆପଣ ଜାଣିଛନ୍ତି ସେ appellant କୁ
My name is there.
ଆପଣ ପୁରା ନିଜେ କହୁଛନ୍ତି ଆପଣ ହଉଛନ୍ତି ନମ୍ବର 4
ଆଜ୍ଞା।
ତେଣୁ ଆମେ କେମିତି କହିବୁ ଯେ 1 କି 2 କି 3 କି ଆପଣ ଲାଷ୍ଟ ନା ଆଉ 5 ବି ଅଛନ୍ତି
ନା ନା
4ଟା ହଉଛି ଲାଷ୍ଟ ନମ୍ବର ତେଣୁ ଏ ଗୋଟେ କାମ କଲେ ହବ ଇଏ ସ୍ପେଶାଲ ଜେଲ ଭୁବନେଶ୍ୱରରେ ଚିଠି ଦେଇଛନ୍ତି ମିଷ୍ଟର ତାଙ୍କୁ ଜେଲ ସୁପରିଟେଣ୍ଡେଣ୍ଟ କୁ କୁହନ୍ତୁ ଅନଲାଇନ ତାଙ୍କୁ ଇଏ କରିବେ ସେ ଯଦି କହିବେ ଯେ ମାନେ ମିଷ୍ଟର ମିଶ୍ରଙ୍କୁ ସେଇ ସି ହୁଏତ କୋଉ ସୋର୍ସରୁ ଜାଣିଥିବେ ତାହେଲେ କିଛି ଅସୁବିଧା ନାହିଁ वकालतनामा ତ ଅଛି ସେ ସାଇନ କରିକିନି we can engage ଜେଲ ସୁପରିଟେଣ୍ଡେଣ୍ଟ ସ୍ପେଶାଲ ଜେଲ ଭୁବନେଶ୍ୱର ୟା ନାଁ ହଉଛି सोमनाथ alias ଭଞ୍ଜ ପୂର୍ତ୍ତି ତେଣୁ ଫୁର୍ତ୍ତି ଲେଖା ଅଛି ହଁ ଫୁର୍ତ୍ତି ତ ଲଞ୍ଚ ପରେ 2ଟା ବେଳକୁ ତାଙ୍କୁ କହିଦିଅନ୍ତୁ appear କରିବେ ହେଲା so you remain present
Yes.
so if he says that yes then there is no problem
There will be a TI parade.
ନାଇଁ ହୁଏତ ଆପଣଙ୍କୁ ସେ କୋଉଠି ଦେଖିଥିବ କଣ କରିଥିବ କିନ୍ତୁ ଆପଣ
ଆଉ ଜଣେ ଅଛନ୍ତି କାଳେ ସେ ହେଇଥିବେ
ସେଇପାଇଁ ପରା ସେ ତେଣୁ ସେ ଯଦି ଆପଣଙ୍କୁ କହିଦବ ତାହେଲେ ଅସୁବିଧା କିଛି ନାହିଁ but otherwise we would have sought for clarification ଏଇ ଟାଇପ ର ହେଇଥାନ୍ତା ନା since in this high court there are 4 ସତ୍ୟନାରାୟଣ ମିଶ୍ର ତେଣୁ which ସତ୍ୟନାରାୟଣ ମିଶ୍ର ତେଣୁ ସେଇଟା ସଲ୍ଭ ହେଇପାରିବ ଏଇ ପ୍ରୋସେସ ରେ
ଦେଖିନଥିବ ଚିହ୍ନଥିବ ସତ୍ୟନାରାୟଣ ମିଶ୍ର କିଏ ସେଟା
ନାଇଁ ନାଇଁ ସେ
ଆମେ 4 ଜଣଙ୍କୁ ଡାକିବୁ
So now this virtual mode facility is available. We are taking advantage of it. So obviously the problem can be sorted out. The other 3, they are also practicing criminal.
One is Satyanarayana Mishra. He is also a legal and financial lawyer.
Oh.
His name is there.
Acha.
Okay.
So let him come, receive and gather.
My lord, with permission, I would like to mention this is the exceptional urgency matter from Court 7. As soon as the notice published, I came here. I am the auction purchaser who has purchased the property 3 years back in 2021. Today, bank is auctioning the property again. So that matter.
So why will entertain such application when DRT is there?
DRT, we have filed a essay, and the essay was dismissed for default a few days back.
File a restoration application there.
Yeah, the restoration application, my lord, filed on.
How many decisions of the Honorable Supreme Court is there? This court is there that when the DRT is in session, this court should not entertain a writ petition. And the Honorable Supreme Court has stated that in spite of our judgment, this is the high courts are entertaining such applications and passing orders. This has also been passed or not?
Yeah, it's not passed. It's technically citing technically difficulties. So
you have, since one alternative efficacious remedy is available and you have already availed the same, but due to your default or negligence, whatever it may be, that has been dismissed. Okay, you have filed a restoration application. Move that application. Why we will entertain, and when the judge in charge, who is he is not, maybe tomorrow he may join, you can move. That's a regular court. It's in nothing exceptional that will take up the matter of the other court unless it cannot wait till tomorrow. And The auction, if it is
My
today, you
lord,
can
it's happening
participate.
today. Auction is happening today.
You can participate. There is no problem. Quote your rates, and tomorrow you may move. If your rate is found to be suitable, it can be given to
My
you.
lord, I have already purchased that thing. That is,
All right. You have purchased, you have availed the loan, you have defaulted in payment of loan.
no, I am
Notices
the
must
auction
have been
purchaser.
You are a auction purchaser.
Auction.
You are an auction purchaser.
Yes,
All
my
right.
lord. Yes,
And
my lord.
still the bank is going for the auction at the instance of whom?
That means you have not deposited the balance amount.
25% as per law we have already deposited,
So
and 75% only after getting the confirmation from the bank we have to deposit. That confirmation is yet to come. They have not given the confirmation.
No. In between, what is the exigency that the bank has again gone for this?
second auction.
What for?
Yeah, because that essay was dismissed for default, and
Yes.
after that,
So you take the forum. You have already availed the forum.
Sure.
He has joined in the VC from Yarpada jail. My lord. But there is some.
Number 3. Item number. चिट्ठी डालो।
सोमनाथ
ସାର୍
ଭଞ୍ଜପୁର୍ତି
ସାର୍
ନା ଭଞ୍ଜପୁର୍ତି ଏଲିଆ ସୋମନାଥ
ଆଜ୍ଞା ସାର୍
ତମର ଗୋଟେ ଚିଠି ଆସିଥିଲା ତମର ଓକିଲ ବାବୁଙ୍କୁ ତମେ ନବାକୁ ଚାହୁଁଛ ଶ୍ରୀ ସତ୍ୟନାରାୟଣ ମିଶ୍ରଙ୍କୁ ବୋଲିକିରି
ସାର୍
ତାଙ୍କୁ ଦେଖିଛ
ନା ସାର୍ ଦେଖିନି
ଆଉ କୋଉ ସତ୍ୟନାରାୟଣ ମିଶ୍ର ବୋଲି କହୁଛ ଆମର ଏଇଠି ସେ ଅଛନ୍ତି ସତ୍ୟନାରାୟଣ ମିଶ୍ର ବାବୁ ଏଇଠି ଅଛନ୍ତି
ସାର୍ ମୁଁ ଜାଣିନି ଏପର୍ଯ୍ୟନ୍ତ
ନାଇଁ ତାଙ୍କୁ ବି ଲିଗାଲ ଏଡ୍ ତରଫରୁ ଆମେ କେସ୍ ପରିଚାଳନା କରିବା ପାଇଁ ଦିଆ ହଉଛି କିନ୍ତୁ 4 ଜଣ ଯେହେତୁ ସତ୍ୟନାରାୟଣ ମିଶ୍ର ଅଛନ୍ତି ଇଏ ସତ୍ୟନାରାୟଣ ମିଶ୍ର 4 ତେଣୁ ତମେ କହିପାରିବ କି କାହା ପାଇଁ ବୋଲିକିରି ନା ତାଙ୍କୁ ଦେଲେ ତମର କିଛି ଅସୁବିଧା ନାହିଁ
ନା ସାର୍ ମୁଁ ଜାଣିନି
ନାଇଁ ତମେ ଜେଲ ସୁପରିଟେଣ୍ଡେଣ୍ଟଙ୍କ ମାଧ୍ୟମରେ ବା ଅନ୍ୟ କୌଣସି ମାଧ୍ୟମରେ ତମେ ଜାଣିବା ଲାଗି ଚାହୁଁଛ ଯେ ତମେ ପ୍ରକୃତରେ କାହାକୁ ଦବ ବୋଲିକିରି ନା ଏ ସତ୍ୟନାରାୟଣ ମିଶ୍ର ବାବୁ ଏଇଠି ଅଛନ୍ତି ତାଙ୍କୁ ଦିଆଯାଇ ପାରିବ ତମେ ସେଇଥିପାଇଁ ଆମେ ତମକୁ ପଚାରିବା ଲାଗି ଚାହିଁଲୁ ତମେ କୁହ ବର୍ତ୍ତମାନ ସତ୍ୟନାରାୟଣ ମିଶ୍ର କିଏ ତମେ ଚାହୁଁଛ ତାଙ୍କୁ ତମେ ନିଜେ ବାହାର କରିକି କହିବ କି କିଏ ବୋଲିକିରି
ନା ସାର୍ ମୁଁ ଜାଣିନି ଆପଣ ଯାହା ଦେବ
ଜାଣିଲ ଏଠୁ କାହାଠୁ ଜାଣିଲ ସତ୍ୟନାରାୟଣ ମିଶ୍ରଙ୍କୁ ଦିଅ ବୋଲିକିରି କିଏ ଲେଖିଦେଲା ଏଇଟା
ସାର୍ ମୁଁ ଜାଣିନି
ନାଇଁ ନାଇଁ ଏଇ ଯୋଉ ତମକୁ ଏଇ ବିଷୟରେ ଲେଖିବା ବିଷୟରେ ତମେ ଜାଣିଛ କି ନାଇଁ
ନାଇଁ ସାର୍
ଲିଙ୍ଗରାଜ ମହାନ୍ତି ଆଗରୁ ତମର ଓକିଲ ଥିଲେ ବୋଲି ତମେ ଜାଣିଛ
ହଁ ଲିଙ୍ଗରାଜ ମହାନ୍ତି
ଜାଣିଥିଲ
ହଁ ଅପିଲ କରିଥିଲେ ସିଏ ଅପିଲ କରିଥିଲେ
ହଁ ସେ ଅପିଲ କରିଥିଲେ ତ ବର୍ତ୍ତମାନ ତମେ ତାଙ୍କୁ ପରିବର୍ତ୍ତନ କରିକି ସତ୍ୟନାରାୟଣ ମିଶ୍ରଙ୍କୁ ଦେବା କଥା ତମେ ଜାଣିନ ଚିଠି ହେଇଛି ବୋଲିକିରି
ନାଇଁ ସାର୍
ଜେଲରୁ ତମେ ଚିଠି ଲେଖିବା କଥା ତମର ମନେ ପଡୁଛି କି ନାଇଁ
ଦସ୍ତଖତ କରିଛୁ
ଦସ୍ତଖତ କରିଛ ନା କେବଳ 2 ସେପ୍ଟେମ୍ବର 22 ରେ 2022 ଚିଠିଟା ଆସିଛି ତମେ କେତେବେଳେ ନିଜେ ଚାହିଁଥିଲ କି ସେ ଲିଙ୍ଗରାଜ ମହାନ୍ତିଙ୍କୁ ପରିବର୍ତ୍ତନ କରିକି ଦେବି ବୋଲିକିରି ଓକିଲ ଆଗେ
ଲିଙ୍ଗରାଜ ମହାନ୍ତି ତ ଫୋନ ଉଠଉନି କଥା ହଉନି
ଆଚ୍ଛା ଠିକ ଅଛି ହଉ ତାମାନେ ତାପରେ ତମେ ଚାହିଁଲ ଯେ ତାଙ୍କୁ ପରିବର୍ତ୍ତନ କରିକି ଆଉ ଜଣଙ୍କୁ ନବ ବୋଲିକିରି କିନ୍ତୁ ସତ୍ୟନାରାୟଣ ମିଶ୍ର ବୋଲି ତମେ ଜାଣିନ କାହାକୁ ଜାଣିଛ ଆଉ ଦବାକୁ ଚାହୁଁଛ ଏଇ ନାଁଟା ତ ତମେ ଜାଣିନି ବୋଲି କହୁଛ ଆଉ କାହାକୁ ଦବା ଲାଗି ତମେ ଚାହୁଁଛ ନା କଣ
ହଁ ସାର୍ ଆପଣଙ୍କ ତରଫରୁ ଦବ ବୋଲେ ଦବ
ଆମ ତରଫରୁ
ନାଟା ତମେ ଦେଲେ ଆମ ତରଫରୁ ଆମେ ଦେବୁ ସରକାର ତାଙ୍କ ତରଫରୁ ତମ ଇଏରେ ଲଢିବେ କିନ୍ତୁ ନାଟା ତମେ ଯଦି କାହାକୁ ଜାଣିଛ ତାହେଲେ ଦବ
ଜାଣିନି ସାର୍।
ତାହେଲେ ଆମେ ଟିକେ ସମୟ ଦେଲେ ତମେ ବୁଝିକିରି କହିବ କି
ହଁ
ଆଉ
ସାର୍।
ଗୋଟେ ତାରିଖ ଆମେ ଦେଲେ ତମେ ବୁଝିକିରି କହିବ କାହାକୁ ଦବା ଲାଗି ଚାହୁଁଛ
ହଁ ସାର୍।
ଆଚ୍ଛା ହଉ କେବେ ରଖିଲେ କେତେ ଦିନ ହେଲେ ହବ ହପ୍ତାଟେ ହେଲେ ହବ
ଆପଣ
ନାଇଁ ତମକୁ 7 ଦିନ ସମୟ ଦେଲେ କହିପାରିବ କି କାହାକୁ ଠିକ କରି ରଖିବ ବୋଲିକିରି
ହଁ ସାର୍।
ଆଚ୍ଛା
लिखी दियंतु item number 45 review the prisoner's petition at flag A wherein prayer has been made for engagement of Satyanarayan Mishra as the advocate. Mr. Satyanarayan Mishra is present in court. Learned counsel submitted that since it is not mentioned in the prisoner's petition regarding Satyanarayan Mishra 4, he is not sure and he has got no personal acquaintance with the appellant. He is not sure whether the appellant intended to engage him as his counsel or not. We asked the learned counsel for the state to have to make necessary contact with the jail superintendent of special jail Bhubaneswar, in which the appellant has been lodged, to appear before us through virtual mode to, from him to confirm whether he intends to engage Mr. Satyanarayan Mishra 4 as his advocate or not. The petitioner appeared through the virtual mode from the special jail Bhubaneswar and submitted that earlier he engaged Mr. Lingaraj Mahanti as his advocate, but since he did not respond to him, he wanted to change his advocate. However, he submitted that he is not having any acquaintance with Satyanarayan Mishra for Learning Council, who is present in court, and seeks some 1 week time to apprise this court as to whom he wanted to engage as his advocate. Out of this matter, as the week हेले पड़े जाउची 8 को पड़े जाउची. We can fix it on 4th also. 4th we can fix. So this is supplementary list in ASL. Out of this matter on 4th July 2024, the appellant shall appear through virtual mode, and on that day at 10:30, the Learning Council for the state shall instruct the superintendent of special jail Bhubaneswar to make necessary arrangement for the appearance of the appellant on the date fixed. Hala? Okay.
4 जुलाई को आमे रखिलु हां
हाँ।
10:30 रे 4 जुलाई କହିବ 4 जुलाई 10:30 ରେ ତମେ କାହାକୁ ଏନଗେଜ କରିବା ଲାଗି ଚାହୁଁଛ ଓକିଲଙ୍କର ନାଁ ଠିକ କରି କହିବ ସେଇଠି ଇଏ କରିବ ତାପରେ ଆମେ କନଫର୍ମ କଲେ ତମକୁ ଏନଗେଜ କରାହବ ହେଲା
ଗୋଟେ ଭଏସ କଣ ଆସୁଛି
ସେଠି ଅନ୍ୟମାନେ ଅଛନ୍ତି ତାଙ୍କ ନେକ୍ସଟ ବିଜି ପାଇଁ
ହଁ ନେକ୍ସଟ
ଠିକ ଅଛି ଚା
Item number 39.
Pardon to mention, my lord. Item 49, I am permitted to receive the paper book. It may be taken up for day after tomorrow.
49 paper book is there.
ଅଛି ଆପଣ ନଉନାହାନ୍ତି କିଏ ମନା କରୁଛି
I am permitted to receive.
ଦେଇଦିଅନ୍ତୁ paper book ଗୋଟେ ତାଙ୍କୁ receive କରିକି ନେଇଯାଆନ୍ତୁ।
The
We are
fee
not passing any order. You receive the
Yes,
paper book
Yes, ma'am.
and get ready.
Yes, please.
We are not adjourning this matter. 2016 matter.
fee copy would be.
Which one? Acha, एक error free copy of the order be handed. So खाली paper book टा दी receive करे नहीं जान तो कौन सी order आओ किसी sign करेंगे हेलो लिखिएगा हाँ yes next.
Item number 39.
Please, your lordship.
Did you communicate to Sadhya Lakshmi
Yes,
Patnaik?
I found.
His junior came, my lord.
हाँ.
You're telling that she want to conduct. No, tell Mr. Mrs. Patnaik to come and
Personally.
personally.
हाँ.
So he is not available today.
मतलब किए conduct करे हो भाई.
ସିଏ ତାଙ୍କ ଜୁନିୟର ଟା ଗୋଟେ ଆସିଲା ଯେ ସିଏ ତାକୁ କହିଥିଲେ କଣ୍ଡକ୍ଟ କରିବା ପାଇଁ ମୁଁ କହିଲି ତମେ ତମ ନାଁ ବି ନାହିଁ so you tell your senior to come and before the court.
Either करीबे कर.
May I please, your lordship?
Just a minute. Item number 39.
39.
Yes.
The appellant is convicted under section 302 IPS undergone imprisonment for life. The appellant has already undergone 17 years of imprisonment. As per the prosecution case is concerned, that on 19/7/2007 at 10 a.m., while the mother was in the house, the accused came and demanded rice from his mother.
Please come to the FIR. Let us see that. 302 life imprisonment, right?
Yes.
Double murder.
See that.
Double murder.
FIR. ମୁଁ ମୁରଲୀଧର ନାୟକ 50 ପିତା ଗୋବର୍ଦ୍ଧନ ନାୟକ
Muralidhar Naik, PW?
He's dead, man.
He is dead.
Not examined, okay.
No.
Next.
ପିତା ଗୋବର୍ଦ୍ଧନ ନାୟକ ଗ୍ରାମ ଖଜୁରୀ ଥାନା ପାପଡ଼ାହାଣ୍ଡି ଆଜି ଅର୍ଥାତ୍ 19/7/2007 ତାରିଖ ଉପରବେଳା ଫାଣ୍ଡି ହାଜର ହୋଇ ଦେବା ରିପୋର୍ଟ ଏଇ କି ଯେ ଆମ ଗ୍ରାମର ରୂପଧର ଜାନି
Rupadhar is the appellant.
ରୂପଧର ଇଜ ଦ ଆପେଲେଣ୍ଟ ଗୋଟେ ପିତା ଶୀତଳ ଜାନି ଆଜି ସକାଳ 10ଟା ଘଣ୍ଟା ସମୟରେ ଆଜି ସମୟରେ ତାର ମା ରତନୀ ଜାନି 35
Deceased ଯିଏ କହିଦେବେ ମତେ.
Man, say Rastani Jani is the deceased.
अच्छा ये deceased किया अच्छा.
Yes.
कौन
And
है?
Yes.
another is the 18 days baby not named. 18 days baby.
ଶୀତଳ ଜାନିକୁ
Male
ଖାଇବା
baby not named.
ଖାଇବା ପାଇଁ ପେଜ ମାଗିଥିଲା ତା ମା ରତନୀ
Petitioner ତା ମା କୁ ମାଗିଲା ଜମି କି ଯେ ଖାଇବା ପାଇଁ ମାନେ ଯିବ ବୋଲି ପେଜ ମାଗିଲା.
ପେଜ ମାଗିଲା
ପେଜ ମାଗିଲେ ଖାଇକି ଯାଇଥାନ୍ତା.
ଆଜ୍ଞା ଆଜ୍ଞା ପେଜ ମାଗିଲା ତା ମା ରତନୀ ଜାନି ପେଜ ନ ଦବାରୁ ରୂପଧର ଜାନି ତା ମା ସହ ଗଣ୍ଡଗୋଳ କଲା ହଠାତ୍ ରୂପଧର ଜାନି ରାଗି ଯାଇ ଗୋଟେ ଗାଗଡା ବା ଧାରୁଆ କଟୁରୀ ଆଣି ତା ମା ରତନୀର ତା 18 ଦିନର ସାନ ପୁଅକୁ ଧରି ଶୋଇଥିବା ଅବସ୍ଥାରେ ପ୍ରଥମ ରତନୀ ଜାନି ବେକ ଉପରେ ହାଣିଦେଲା.
just a minute. ଏ ଯୋଉ ସାନ ପୁଅଟି କାହାର ପୁଅ?
His brother.
ତାର brother
ତା ନିଜ ସାନ ଭାଇ
of the
ତାଙ୍କର.
accused.
ଓହୋ ଆଚ୍ଛା.
ହାଣିଦେଲା ଓ ତାପରେ ତା ପାଖରେ ଶୋଇଥିବା 8 ଦିନ ପୁଅକୁ ମଧ୍ୟ ସେଇ କଟୁରୀରେ ତା ବେକ ପଛୁ ପାଖରୁ ମାରିଦେଲା ଯାହା ଫଳରେ ପ୍ରଚୁର ରକ୍ତସ୍ରାବ ହୋଇ ଘଟଣାସ୍ଥଳରେ ହିଁ ରତନୀ ଜାନି ଓ ତାର 8 ଦିନର ପୁଅର ମୃତ୍ୟୁ ହୋଇଗଲା. ତାପରେ ଆସାମୀ ରୂପଧର ଜାନି ମାରିଥିବା କଟୁରୀ କେଉଁଠାରେ ପକାଇ ଦେଇ ତାଙ୍କ ଘରୁ ଅନ୍ୟ ଗୋଟେ ଟାଙ୍ଗିଆ ଓ କିଛି ଚାଉଳ ଧରି ଫେରାର ହୋଇଯିବା ପାଇଁ କୁଆଡେ ପଳାଇଗଲା. ଏ ଖବର ଘାସିନୀ ଜାନି ଠାରୁ ପାଇ ତା ବାପା ଶୀତଳ ଜାନି ଓ ତାପରେ ଅର୍ଜୁନ ଜାନି ତା ସ୍ତ୍ରୀ
କି ତା ଦେହରେ ୱିଟନେସ୍ କିଏ ଅଛନ୍ତି ଟିକେ କୁହନ୍ତୁ.
ଆଇ ୱିଟନେସ୍ ଅଛି.
ନାଇଁ ଏଇ ଯୋଉ ନାଁ ଗୁଡାକ ଆସୁଛି.
ଶୀତଳ ଜାନି PW5.
କିଏ
ଶୀତଳ ଜାନି.
No, he is not the eyewitness. He was not present.
Has he said that eyewitness? ଆମର ପ୍ରଶ୍ନ ହଉଛି ଯେ
ହଁ
ଯୋଉମାନଙ୍କର ନାଁ ଆସୁଛି
ହଁ
ତାଙ୍କ ଭିତରୁ ଯଦି କିଏ ଏକ୍ସାମିନ ହେଇଛନ୍ତି ସେଗୁଡାକ ଆମକୁ କହିବେ।
Now you
ଆଚ୍ଛା ଆଚ୍ଛା
start. ଏହି ଖବର
ହଁ
ଘାସିନି ଜାନି
ଖାସିନି
ଘାସିନି ଜାନି କେତେ ଏକ୍ସାମିନ ହେଇଛି
PW3
ହଁ ସେଇଆକୁ
PW3 she claims to be the eyewitness.
It's all right,
She is
sir.
the child witness.
all right that will come
ହଁ
later
ଏ ଘାସିନୀ ଜାନିଙ୍କ ଠାରୁ ପାଇ ତାର ବାପା
ଶୀତଳ
ଜାନି
PW5
PW5
ହଁ
ଶୀତଳ ଜାନି ତାପରେ ଅର୍ଜୁନ ଜାନି ତା ସ୍ତ୍ରୀ ଧନବନ୍ତୀ ଜାନି
କିଏ ଏମାନେ କିଏ
ଅର୍ଜୁନ ଜାନି is PW4
PW4
ସ୍ତ୍ରୀ ଧନମତୀ ଜାନି has not been examined.
ଏକ୍ସାମ୍
ଗାଁ ମେମ୍ବର ଓ ଗ୍ରାମର ଅନ୍ୟ ଲୋକମାନେ ଜମା ହୋଇ ଘଟଣା ବିଷୟରେ ଜଣାଇଲେ। ଶୀତଳ ଜାନି ଅନ୍ୟ କେହି ଲୋକ ଏହି ଅଘଟଣା ସମୟରେ ରିପୋର୍ଟ ନ ଦେବାରୁ ମୁଁ ଗ୍ରାମ ଭଦ୍ର ବ୍ୟକ୍ତି ହିସାବରେ ଗ୍ରାମ ଲୋକଙ୍କ ଅନୁରୋଧ ରକ୍ଷା କରି ସରପଞ୍ଚ ସାନ ବରଲା ସାଙ୍ଗରେ ଧରି
ସିଏ ହେଲେ ସରପଞ୍ଚ ହେଲେ PW2
ସାନବାର୍ଲି
ସାନବାର୍ଲି
PW2
ଏହି ରିପୋର୍ଟ ଦେଉଅଛି। ଏହାର ତଦନ୍ତକାରୀ କରାଯାଉ। ଦୋଷୀ ରୂପଧର ଜାନି ପ୍ରତି କଠୋର ଦଣ୍ଡ ଦେବାର ବ୍ୟବସ୍ଥା କରନ୍ତୁ, ଯାହାଠୁ ସେ ବିନା କାରଣରେ 2 ଗୋଟି ମର୍ଡର କରିଛି, ଏହିପରିକି ଗୋଟାଏ 18 ଦିନର ନିର୍ଦ୍ଦୋଷ ଛୁଆର ମର୍ଡର କରିବାରୁ ପଛଘୁଞ୍ଚା ଦେଇନି। ଇତି ମୁରଲୀଧର ନାୟକ।
Now you come to the charge. Case 38.
38.
Hmm.
38 is not the charge. Oh, no, 38. That you on or about the 19th day of the July 2007 at about 10 a.m. at village Khajuri committed murder intentionally causing the death of Ratani Jani and her 18-day male baby, hereby committed an offense punishable under section 302 of the Indian Penal Code and within my cognizance.
It's all right. So
The accused denied, proudly denied. In his accused statement, stated that false case has been
just
started.
a minute. Mr. Tripathi, is there any eyewitness to the other?
PW3
Who are the eyewitnesses?
PW3 the only eyewitness,
PW3,
sister of the accused.
sister of the appellant, right? Okay, he is one. Apart from the eyewitness statement, what else is there?
PW4 saw after the occurrence, he was going with the bag of rice and the tangia, with one tangia.
PW4.
Four.
PW4.
saw the accused leaving the
place. Acha. Seeing leaving the place. Okay. Place of occurrence.
PW4 is a hearsay.
अरे आपण ବ୍ୟସ୍ତ କଣ ପାଇଁ ହଉଛନ୍ତି? ଆମେ କେସ୍ ଟା ଜାଣି ସାରୁ ଆପଣ ପଢିଥିବେ। So one is eyewitness, the other has seen him leaving the place.
And the other person who died, my lord, that Arjun Naik. Who has seen that
informant charge them. ଆଉ କଣ ଅଛି?
That is the evidence
leading to
recovery
discovery
of that weapon. Weapon recovered from a boat set.
At the instance of the appellant. See evidence କିଏ କହୁଛି?
PW5B କହିଛି ଆଉ ଜଣେ କିଏ?
Leading to discovery of weapon of offense. ये गोटे एविडेंस आसिला एथरे आईओ रो थिबो निश्चय आईओ केते पीडब्ल्यू 8 आउ इंडिपेंडेंट विटनेस बोर्ड अछि
There is no order.
Okay, कोई आंसर पॉइंट रे
PW5 has not stated this.
Only IO.
PW5.
Acha, we'll see that during course of hearing. So anything else we just want to confirm and then go to the evidence.
That is there.
That's all. Acha, who is the doctor who conducted PM?
PW1.
PW1 PM doctor. Your good name learned in council is Prem Kumar Mahanti, right?
Yes, yes.
So let us come to the PM report first, then we'll go to the other. Come to the evidence of PW1,
PW1.
page 44.
Yes. On 27/2007, I was working as MO in Dabuga PHC. On that day, a police requisition, I conducted the postmortem examination over this body of 18 days male baby, not named, son of Sitala Jani of village Kajugiri, post Paprahandi, district Nabrangpur, and found the following: a deep cut injury on the neck, on the back of the neck, cutting the skin, muscle, and vertebra column on size 3:1:2. The nature of the death is homicidal in nature, caused within 24 hours of the postmortem examination, and death is due to hypovolemic shock caused by deep cut injury. Exhibit 1 is the PM report. Exhibit 1 by 1 is my signature. On the same day, the police requisition, I conducted the postmortem examination of the dead body of Ratni Jani, wife of Sital Jani, aged about 35 years. Village had found the following: the cut injury is present on the back of the neck, size 7:1:2, with cutting muscle and bone. The nature of the injury is homicidal in nature, which is caused within 24 hours of the postmortem examination, and death is hypovolemic shock caused by deep cut injury or to the nervous system. Report is my signature. On 23/7/2000, I got a requisition from CI Paprahandi with the weapon of offense for its examination. Whether the injuries are possible and the said weapon over the body of the deceased Utanjani and 18 days male baby, I opined that the injuries are possible by the said weapon on both deceased. In reply to query number 2, I opined that the death can be caused by ordinary course and nature. Why the said weapon, it is
If it is inflicted.
if it is inflicted on the back of the neck. On the reply to the query number 3, I opined that the blow given on the neck can cause death. My reply to the query is my signature. I had also examined the weapon of offense. The MOI is the said weapon. Cross examination. I did not put my signature on the material object identified by me. The injuries mentioned on the report can be possible if fall on the sharp cutting stone.
Okay.
My lord.
Now
There
you
is
come to the
contract
evidence of the PW3.
PW3, my lord. My PW3 is the child witness of
Just a minute.
uh,
5 years old. Okay.
he is around 5 years old. Since witness present in the doc is child, I am inclined to put question in order to assess our understanding about the fact on the questions put to her and regarding her capability to give rational answer.
So leave it. He is found to be a competent witness. Now you come to paragraph number 2, page 40.
Paragraph number 2. I know the accused.
Hmm.
The witness pointed out her finger towards the accused stood in the dock, who is standing, telling that is the elder brother named Rukubaya. Rukubaya means
Oh,
is a
that
mad
means this boy is the younger brother of the appellant.
young of the appellant, the sister
Sister of the
of the appellant.
Okay.
Yes.
Appellant sisters.
On the date of the incident, my father was not in the house, as he had been to Dangar for plowing land.
Just a minute. I know the accused. The witness has pointed out her finger towards the accused who is in the dock, telling that is his her elder brother. ताମାନେ तार भाई ना बड़ भाई परा
बड़ भाई
हाँ भाई भौणी अच्छा अच्छा
आज्ञा
हाँ ये झीटा बोध ओके हाँ ठीक अछि
I was present in the house. My mother and my little brother were sleeping in the kitchen room.
they are the two deceased. Okay.
Yes, yes. The accused was also present in the house. He demanded tobacco in the to my mother, but in the FIR it is written as peja. My mother refused to supply tobacco. Thereafter, the accused, my elder brother, demanded rice from my mother. On the denial of my mother, the accused suddenly dealt blow by means of gagada on the neck of my mother and little baby. Then the accused rushed towards me with a view to assault by means of gagada. I ran away from the spot. I raised hulla, drawing the attention of the people. The accused fled away from the spot. Then the accused fled away from the spot, throwing the gagada. On receipt of the information, my father came along with village people to the house. My mother and little brother were found lying in the house with pool of blood. I have seen the commission of the murder committed by my elder brother, the accused. The witness identified the weapon of offense, showing to her and told that by means of the weapon, the accused dealt the blow to my mother and my little brother. Cross examination. I am reading in class. I was unable to walk at the time when I saw the incident. In the chief, she still that she ran away. That the accused also called as Buttu Baya. The witness properly identified the father of the accused. The name of my mother is attorney. The accused was roaming hither and thither in the house, having mental disorder. Nobody was present at the time of the incident except myself in the said house. There are houses adjoining to my houses. I cannot say the name of the neighboring houses. The village, just hearing my hula, immediately rushed to the spot. I was called by the police and taken to police station. I located at Nabrangpur. I was called by police one day after the incident. I accompanied by my father to the police station. After chasing, then she says, after chasing me, I immediately run towards dead palm trees, which was a distance from our house. The accused, though chased after me, could not catch me. I cannot say the names of the person to whom I met them on the way. The accused was chasing me without holding any weapon. But in the FIR story, they said that he was holding on tangia and rice. I had once came to the court prior to the case. It is not a fact that I have not stated before the court earlier that when my brother demanded rice from my mother, the accused committed assault by means of gagada, and that I was chased by the accused for committing the assault. It is not a fact that I have not stated before the court earlier that I was not chased by the accused.
ପିଛୁଆଟା ଟିକେ 161 ଟା ଟିକେ ବାହାର କଲ ଯୋଉ ତା ନାଁ ହଉଛି ଘସୁଇ ନା କଣ
Ghesni.
ହଁ
Ghesni.
ଘାସନି
Ghesni.
ହଁ ଏଇଟା ଘାସିନି ଜାନି ଆଚ୍ଛା ତା ବାପା ନାଁ ହଉଛି ଶୀତଳ ଜାନି एदे तो अच्छी 161 ରେ ମଧ୍ୟ ଅଛି ଯେ ମୋତେ ସେଇ ପାଖରେ ଦେଖି ଭାଇ ରୂପଧର ଗାଗଡ଼ା ଧରି ମୋତେ ଧପଡ଼ି ଆଣିବାରୁ ମୁଁ ଭୟରେ ପାଟି କରି ଦୌଡ଼ି ଯାଇ ପାଖରେ କାମ କରୁଥିବା ଏଆଇ ମାନ ଘଟଣା ସବୁ କହିଲି। So what is your submission, Mr.
My
Ravi?
submission is that the learned court convicted the accused on basis of the evidence of PW 3, the daughter of the deceased.
No,
With-
we are asking you what is your submission, what is your comments on the evidence of this child witness PW5. We'll go step by step because he appears to be the star witness on
Yes.
behalf of the prosecution.
Yes.
Yes.
In the chief, she says that the accused chased her, but in the cross examination, she says he is unable to walk at the time when she saw the incident. This is a contradiction to the statement made by her in the chief mind. Then she says that she immediately went and raised halla, but PW4 in his statement did not say that she has raised a halla. She said that only she stated that the accused killed. I'm placing PW4, my lord.
In the leading to
Is it-
discovery, he is that person.
Leading
PW4.
discovery, but
Witness to leading to discovery. My
but-
lord was asking the witness PW4.
but he says that I have not visited the police station.
Just a minute.
Yes. PW4 is the hearsay witness. He was not present.
Just see, this witness
Yes.
is such a witness who is not only related to the deceased persons, but also related to the appellant.
Appellant, yes.
Right?
Yes.
So one side, his own elder brother is there.
Yes.
The other side, his mother, sorry, her mother, and her younger brother is there.
Yes.
So her presence at the spot in her own house, so it cannot be disputed. And when she has stated that what she has seen at the place of occurrence, and it is corroborated by the medical evidence. She has given from the beginning what has happened, how the accused asked for tobacco, then how again he asked for this, what is it?
But the FIR,
Rice,
but FIR story says that the accused asked for only peja, not tobacco.
So see, pejo magusi,
Not supported by.
that is
Again.
not the material discrepancy.
No.
Material discrepancy ହେଇଥାନ୍ତା ଯଦି so far as assault part ରେ ସେମିତି କିଛି discrepancy ଥାନ୍ତା। ଯୋଉ ଘଟଣାଟା ସେ FIR ରେ କହିଛି relating to the assault on her mother as well as on her younger brother, if it is found to be consistent with what she has deposed in court and it is corroborated by the medical evidence. So what have you, we are posing a question to you that why this witness who has been found to be a competent witness after the assessment made by the London trial court be disbelieved.
My lord, there is a lot of discrepancies
You
in the witness, my lord.
discrepancies.
Yes, yes.
ଆପଣ ଗୋଟେ discrepancy କହିଲେ ଯେ ସିଏ cross examination ରେ କହିଲା ଯେ I was unable to walk at the time when I saw the incident.
Then how could she
I
run?
ଆପଣ କହିଯାଆନ୍ତୁ how
ଆଜ୍ଞା।
could she run? That's a we'll explain how she could run. But the question is that ଏଇଟା ଗୋଟେ discrepancy ଆଉ କଣ ସେମିତି discrepancy
There is discrepancy that the
ପେଜ ତ ସେ କହିଛି କିନ୍ତୁ ତା
Uh,
ସାଙ୍ଗରେ ଦବାକୁ ବି କହିଛି।
there is no mention of Hewla by PW4 in his cross examination. He stated that his house is half kilometer from this spot. And PW4 stated, my lord.
ଓହୋ ଆପଣ
ଆପଣ କୁଆଡେ ପଳେଇଲେ?
ଆପଣ କୁଆଡେ ଯାଉଛନ୍ତି ଭାଇ
ଆଜ୍ଞା।
ଆପଣ PW5 पर ଆମେ we are
ନାଇଁ,
in evidence of PW5
3. PW5 is the PW3, my lord.
Eyewitness.
PW3 sorry
Eyewitness, yes.
we are in the evidence of PW3. So we are posing a question. You have placed the evidence,
Yes.
chief examination, cross examination. So
Hmm.
we want to know from you what are your points for that this PW3 is not a truthful witness. That is our question. One, you have said that she was unable to walk at the time of incident. Then how she could run? That is your. You see, somebody might be there, but she say that I was not. But when the person came to assault him with holding the weapon, she might have got courage or something like that. He could have tried to escape from the spot. So it is not a is not found to be a the handicap that he could not. So she କହିଲା ମୁଁ ଚାଲି ପାରୁ ନଥିଲି କିନ୍ତୁ ଯେତେବେଳେ ସେଇ ପୋଜିସନ ରେ ଜଣେ ତାକୁ assault କରିକିନା ଆସିବ ତାର ଯୋଉ ମାଇଣ୍ଡ ରେ ଆସିବ ସେଠି ହୁଏତ ତାକୁ ସେଇ ଶକ୍ତି ଯୋଗେଇ ଦେଇଥିବ ଯେ ସିଏ try to escape from the କାରଣ ସିଏ already ଦିଟା ମର୍ଡର ଦେଖି ସାରିଲାଣି ତା ସାମ୍ନାରେ
It means she got dumbfounded. Seeing the incident,
Yes.
she got dumbfounded.
Dumbfounded and she
couldn't walk.
Yeah.
That's a kind of reaction that she is showing.
A 3-year-old child cannot run half kilometer and call his father, who was plowing in the field.
Cannot.
Yes.
5 years old cannot.
No.
5-year-old child cannot run for
And
1
also she
kilometer.
cannot say who came, who all came while she was running, man.
No, what is the how you say? How a 5-year-old child is handicapped in not running to half a kilometer or not seeing this? What is the how you say this? What is the analogy according to you?
In the shock, one cannot run
Again,
half kilometer and call.
My senior brother has told you very categorically that it is the reaction of a person when somebody will come to chase. Even 2-year-old child, if you show a stick, he will start running. What of 5 years old? ତାକୁ ଯଦି ଆପଣ ହାତଟେ ଦେଖିବେ ଛୋଟ ପିଲାକୁ ବି ସେ ବି ମୁଣ୍ଡ ଏମିତି କରିଦବ. So that is the kind of reaction. Here she can move, he can move.
Also, there is also that.
And she knows that her father is working nearby.
She told that the accused was running. Running.
He saw.
She saw that the accused was running.
Please. I saw a film. Of course, it's a film. That lady, she was in the wheelchair. Okay. So the hero, he acted like a villain. He tried to show a weapon that is a knife to assault her. And she was shocked. Perhaps I will be assaulted. So in that way, she left the wheelchair and tried to escape from the spot. So, and ultimately, she was able to walk. So that happens. Sometimes we have also that. Suppose upon kiye kete dur କୋଉ position ରେ reaction କରିବ.
And nothing is there in the cross examination that at what distance she was there from the accused. Nothing is there. So you cannot say, let's see, even though the elderly person chased her, you say
Yes.
that she is an elderly person, she is a child. If she would have been chased, actually, then probably she would have been caught. No, you
Yes.
cannot say. You cannot say. In absence of any evidence, you cannot say. There is
But
no evidence
one
that-
cannot run by holding one rice bag and also a tangia.
What
But
do
which is stated by PW4. But she says that she was that accused
she
was
was
chasing
holding
without
a
any
tangia and
weapon of
rice.
offense. The
Ah.
tangia and the rice was also not seized by
No,
the
that
policeman.
comes later. That comes. One cannot run with a
With
with that.
20 kg of rice and one tangia, one
No.
cannot run.
One cannot.
No. 20 kilo ରାଇ ଚାଉଳ ଧରି ଗୋଟେ ଟାଙ୍ଗିଆ ଧରି one cannot run. But ଟାଙ୍ଗିଆ is also
What about your comments on
Yes.
this particular witness, PW3? So anything if you want to further say about this
Yes.
witness, you can comment.
Yes, there is no mention of holla in PW chief, my lord. In the cross examination, he stated that the house is half kilometer from spot. That PW4 stated. It is submitted that one cannot hear a holla half kilometer away from and reach the spot immediately. He stated that he found the accused running with the alleged weapon and 20 kg of rice. But in the affair, it is stated that the accused threw away the cutlery somewhere and took one tangia and some rice. It is humbly submitted that neither the tangia nor the rice has been recovered by the police. It is submitted that the PW3 did not mention about the accused taking rice and one tangia. It is also stated in the affair that one Arjun Jani, his wife, Damayanti Jani, village member and other village visited the spot. So also PW did not 4W did not state that any
You have
villagers
prepared,
visited in the house.
a written note of argument.
Yes, yes.
So why are you not giving?
I have only one single copy. I am not.
If you want to paste from the written note, you should give it to the your brother also.
I have not made a copy out of it.
No, the copy can be made by. Is it? Have you checked it finally?
No, I thought this matter will not reach, but I have not made it finally.
Mr. Counsel, you are arguing a 302 case.
Yes, ma'am.
And any kind of negligence on your part to argue the matter, the person will be there in the jail for throughout the life unless the appropriate government passes an order for remission or commutation of sentence, invoking power under 32, 33, 33A.
Ma'am.
So you should be that careful. You are
Ma'am.
arguing a
Sorry.
302 case in the High Court.
Ma'am.
So your argument, your standard of argument, your preparation, it should be to that height.
I have prepared,
And
but I
don't
have not
forget that
prepared.
this proceeding is being live streamed. Everybody is watching you now.
Ma'am. Sorry. Then I'll let this matter come next week. I'll.
No. If you are not prepared, then you should have said so. It's not a joke in arguing a 302 case in the High Court in appeal. If you are not prepared, a child witness. So what is your preparation that how a evidence of the child witness is to be dealt with?
And I have a decision to that effect.
What decisions you have brought with you? A child witness, how his evidence is to be dealt with, and what is
It is Kishan versus State of Haryana.
What read?
Read it, read it. Please give the citation.
Citation is Kishan versus State of
Kishan, K-I.
KRISHAN,
Krishna.
Kishan versus State of
Krishan.
State of Haryana
Just a minute. State of Haryana. Yes.
on 25th July 2004.
No, what
It
is
is
the
a-
citation reference?
It is on this Honorable Supreme Court.
What is that? AIR, SEC, what is that?
I have got it from the net.
Sir, not that.
अच्छा केबे का डिसीजन देखिले डेट ऑफ जजमेंट
2021
नहीं डेट टा देखो
2024
डेट ऑफ जजमेंट मेंशन ही नहीं
25 जनवरी 2024
हाँ 25 जनवरी 2024 बाहर कर देख लो प्रिंट आउट कर देंगे नहीं print out. Decision rendered by Honorable Justice.
No, sorry. This is regarding recovery. Recovery.
Which section really in the Evidence Act deals with the evidence of a childhood? Which particular section of the Evidence Act? That
118.
Yes, very correct. So when the voir dire is taken of the child witness, so what are the things to be looked into?
It has to be dealt with much cautious manner.
So
Yes.
how it is different than the
Why
fact?
This is the judgment.
Mr. Counsel, why it is stated that the witness of the child witness evidence is to be, as you said, cautiously dealt with? Why? What is the reason behind it?
Because a child is of tender years.
Child means the tender years.
Tender years. They used to be easily tutored
That is right.
by the other witness or
Any
by
person,
any person.
Yes.
So therefore they have to handle with care.
Okay.
Yes.
So the court has to be careful enough
in dealing with the child witness.
While dealing with the child witness, but merely because he is a child witness, his evidence cannot be discarded. That's why you are examining.
And it is to be corroborated, my lord. Here is the judgment. It is Bansi and others, national versus state of UP and others.
That is already yes.
Yes,
No, here it is the occurrence took place inside a house
my lord.
where only these three persons were present. Two are
Yes,
deceased.
yes.
One is the child.
One
So
is the child.
from which source you are say that from corroboration will be sought for? Only corroboration can be get that before the person before whom she disclosed. In that source you can get corroboration from the spot where from if you would have taken place at a public place or where other persons are available.
Yes.
And a child witness is giving the statement, matter is different. But if it inside the house it has taken place, his own or her own house, where in her front the appellant killed the mother and the child. So totally four, out of which one is the appellant, one is the witness, two are deceased. They are where from you get the independent corroboration, as you said.
Independent means the medical witness, also the serological report.
Most importantly, here the child witness is related to the appellant and the deceased.
Yes, ma'am.
Whether that is the fact in that case?
Yes.
That is also the fact.
Yes.
That the appellant was related to the witness.
Panchi versus others in state.
That is the fact.
आपण जेतेबेले गोटे रेशियो प्लेस करिवे फैक्चुअल सिनेरियो मध्य आइडेंटिकल हवा दरकार कारण फैक्ट रे ट्विस्ट आसी गले डिसीजन बदली जीवो.
Otherwise it is a principle. So ratio that you have to follow and we will be following it. But if the actually your case is also similar to the one where the court is giving a view and saying that yes, in such situation also, the child witness is not to be believed, then things are different. And if that is not so, then principles are there that we have to follow. How the witness of a child, evidence of a child witness is to be taken. That those are all ratio.
Yes.
In this case, he has followed that paraphernalia also. In this case, he has followed that. He understood that question and given rational answer that was mentioned in page number 3.
No, that is there. We have seen it.
That
That
is
he
the natural witness.
puts put some questions. Each question, what answer has been given.
Certified.
They are certified.
Yeah.
That is very much necessary also for this court to know whether he is a rightly judged as a competent witness or not.
Right.
So that is the why in some of the decisions it is stated that the trial court should also record what the questions it put to the witness, child witness, what answers he given, and simultaneously his satisfaction that yes, he is able to understand the question, answer it rationally, and therefore I found to be a him or her a competent witness. That has he has done.
Well, actually, decision is that Panchi and others versus state of UP and others. In this case,
अरे ये डिसीजन टा कहीं प्लेस कला हम बाहर
no, sir, that is
regarding
that is
weapon of offense.
weapon of offense.
अच्छा ठीक है
It is a this is the wrongly placed that decision. This is the
आपण जो चाइल्ड विटनेस रो
ଏଇଟା ହେଲା ଯେ Panchi versus and others versus state of UP and others.
पंची
Panchi and others versus state of UP and others.
State of UP
19 August 1998.
Other be another citation 19th August
1998.
98 देखिले এটা কোন কোথায় আছে citation গুড়া SCC ରୁ এত বার করে দেন
1998 Supreme Court page
AIR 1998
Supreme Court
page
2726
2726 okay କୋଉ paragraph ଟା ଦେଖିଲେ
Paragraph is
paragraph ହେଇନି ଆଉ ପଢନ୍ତୁ ଯଦି paragraph ହେଇନି ପଢନ୍ତୁ
they have that reason is relied by another decision where it is said that court have laid down the evidence of child must find adequate corroboration before it is relied on. It is the rule of the practical wisdom of law. Prakash and other versus State of Madhya Pradesh 1992 bracket 4 SCC 225.
That factual aspect in the Panchi case has to be seen.
Yes, factual is that bad blood which existed between two families living next door to each other resulted in the extermination of all the adult members of one family and the consequent judicial verdict to send all the living members of the other family to gallows. 4 members of the family of the accused became killer of 4 members of other family irrespective of gender difference of both sides. A glimpse of at the injuries on the mangled dead body would have convicted the onlooker that the none among the victims could have been saved. Even the most advanced sophisticated medical facilities, death of all of them would have been instantaneous. Such injuries clearly reflect the resolve of the killer that every one of the victims should have been snuffed out of the worldly existence. Fact of two brief collaboration, the house where all the accused are living, situated adjacent to the house where all the deceased
Yes, that is exactly what my senior brother has pointed out.
Man.
So it is the factual scenario in that case is that there are scope for others to witness the incident. And here the child witness has also deposed. In that case, a corroboration is a must. Here is a scenario where there is no scope for any outsider or anybody else other than the members of family could have witnessed the incident. And the presence of the child witness is quite natural, which has not been disputed in the fact also. You have not disputed that fact in the evidence that she was not there. Has it been disputed?
No.
So it has not been disputed. So the presence of the child witness is quite natural in this case. Now, in that case again, the extent to which the witness had the scope to see the occurrence is also a question, because she had given a glimpse of the incident. Here it is she and she alone who has seen the entire thing. So there was no such situation where the occurrence that has been witnessed by the witness can also be doubted. There is a doubt, because at which point she was there. If 4 persons have been killed in that case and 4 accused persons are there. It is not the situation here. So factually you have to distinguish that yes, this is the case where the fact is akin to the fact that has been mentioned in that decision. That is how we can. Otherwise principles are there, yes.
The contradictions which you are pointing out, a tobacco କଥା କହି ନଥିଲା, ଏଠି ପ୍ରଥମ ଥର ପାଇଁ introduce କରୁଛି, that does not affect the substratum of the case. ସେଇ ଗୁଡାକ ସେଇ ଯୋଉ discrepancies ଗୁଡାକ ଆପଣ point out କରୁଛନ୍ତି, ସେ ତା ଦ୍ୱାରା ଏଇ witness ଯାହା evidence
Demolish
କହିଛି, এটা cannot be demolished in that way. You have to bring out certain thing तार जोड़ा very foundation को ये होती हो by इमिति किसी discrepancies थियो जो आई विटनेस हिसाब रे जहाँ कहिछि सेथरे किछि संदेह सृष्टि करथिबो, otherwise से टबाको कहि नथिला, से कहला सेठी पेजियो कथा कहिथला, एठी टबाको ऐड करूछि, तेणु गोटा truthful witness नो, it cannot be like that.
So in that case, even if the court would have considered the witness to be a competent witness, it is from the manner in which she has answered in the evidence or in the cross-examination. If it would have gone inconsistent, completely erratic, and only a piece of evidence that she has seen the murder, then probably we could have also seen that no, the child witness is not believable, truthful. But there is a consistency in it.
The recovery of witness is also the
Recovery
weapon of offense is
that will
also.
come. That will come. Suppose no weapon is recovered, then what happens? That also will come. We'll come on that. Now we are only on the child witness because this is the star witness. If she is believed to be the truthful and natural witness, then what will be the consequence of the case? That is one part. Then comes, if she is not believed to be a truthful witness, then what is the case? That part will go. Will go.
So what has been pointed out, competency is one thing found out, or presence at the spot, or relationship with deceased and so also with the appellant, okay, or evidence is getting corroboration from the medical evidence, right? These are the things which we got on the evidence of this witness coupled with the doctor who has conducted post-mortem examination. So we asked you again that if you have got any other comments on this child witness, then we'll go to the other, of course, the other witness, because if you have prepared a note, in your note, whether you have mentioned anything apart from what you have stated, argued before us about this child witness, that these are the reasons for which we should not place any reliance on PW3. In page number 50 of the cross-examination, she very categorically stated 1, 2, 3, 4, 5, 6th line from the top of that, that nobody was present at the time of incident except myself in the said house. So this is that corroboration which you are, this is the answer.
How clear the witness is. And she is facing a cross-examination by a trained lawyer.
And what she has stated about the, after one, two sentence, the villagers hearing my halla immediately rushed to the spot. So were there any villagers have been examined?
PW4, my lord. And
PW4.
the other, the informant who died.
Okay.
PW4 was present.
What he has seen?
See,
PW4.
he raised the halla after they came and found, but they were waiting.
Then we'll go to the PW4. Let us see. So this villagers means one of them has been examined as PW4. Okay. Come to the evidence of PW4.
PW4. I know the accused and the deceased named Ratni. The incident took place about 2 years back at 10 a.m. Hearing PW3 named
Hearing
Visi-
halla.
Hearing Halla.
Hearing halla, PW3.
Halla. Named Halla is cut, deleted.
No. On hearing the hulla of PW3,
that the accused committed murder of her mother and brother, who is 18 days old, I, along with other villagers, rushed to the spot, and the witness came. Ghasni was found running towards his father. On reaching the spot, we found the accused running away with alleged weapon and some rice about 20 kg. We also found that the deceased and her little kid lying dead on the ground with pool of blood. The father of the accused, Khasi, sometimes thereafter came to the spot. On being asked, Ghasni told that since her mother denied to provide any rice, the accused by means of Gagada dealt blow in her neck. Injuries were found on the neck of the both of the deceased. The Sarpanch of our village, one Murali Naik, proceeded to the PS to lodge a report. The police came and held inquest over the dead body. E5/2 is my signature on the inquest report. The police collected the sample earth and blood stained earth from the spot. Exhibit 7 is the seizure list. Exhibit 7/1 is my signature. The police seized the wearing apparels of the accused. Exhibit 8 is the seizure list. Exhibit 8/1 is my signature. The accused, while in the police custody, led the police to his house and gave recovery of Gagada from the goat shed. And the said weapon was seized in my presence. Exhibit 9 is the seizure list. The witness identified the seized Gagada seized by the police. The accused was called as Baya by some villagers. Cross examination by defense. The witness Gisini was found running, being cried. My house is half kilometer away from the spot. When we reached the spot, found the dead bodies inside the house and no other persons were available in the house. The weapons of offense Gagada is generally available in the local area. The accused was found carrying the gunny bag containing some rice. The house of Devojani Chitrajani adjoining to the house of the deceased. When the witness Khasni raised halla, by the time her father was at a distance about half a kilometer from my house. The Sarpanch of the village reached on the day at 10 a.m. On the very day, police took the incriminating articles. On the very date at 11 a.m., the police arrested the accused. But PW8, the police says that he arrested the accused at 9 p.m. at the.
Complete କରିଦିଅନ୍ତୁ
हाँ.
ତାପରେ comment କରିବେ.
हाँ. On the very day at 11 a.m., the police arrested the accused. I did not go to the police station in connection with this case. The police prepared documents at 4 p.m. and obtained my signature. It is not a fact that I have not stated before the police that the accused concealed the weapon of offense inside the goods shed. It is not a fact I am deposing false.
So now you have placed PW4.
4.
So we will now discuss. We want a reply from you. PW3 ଏବଂ PW4 এই evidence ଟାକୁ ଆମେ ଯଦି ନବୁ PW3 ର evidence ହେଲା ଘଟଣା ପରେ ଦେଖିକିନି ସେ କଣ କଲା? He raised hulla.
He raised halla.
And it drew the attention of the villagers.
Yes.
The villagers also came to this spot.
Came.
So one of those villagers has been examined as PW4. He also corroborated the evidence of PW3 that on hearing Halla, we came to the spot. We found that the appellant was running away and the two deceased persons were lying dead with injuries in a pool of blood. Okay. So the conduct of PW3, what he has shouted, drew the attention again for disclosure before the others. This is relevant under Section 6 of the Evidence Act.
Yes.
So a witness, what he is doing immediately prior to or after the that is relevant. So this witness conduct in disclosing immediately after the other persons like PW4 that these appellant is the author of the crime.
And also the manner in which
हाँ,
Ghasini told that since her mother denied to provide any rice, the accused by means of Bagada dealt
So
blows.
the thing which you are seeking for by showing that decision that the child witness evidence must get corroboration.
Yes.
It's getting corroboration from this evidence of PW4.
PW4, first of all, he is a hearsay witness.
What hearsay means?
Hearsay. He was not present at the spot when the incident
person who is not present at the spot,
yes,
his evidence is hearsay in nature.
yes,
He cannot say about any other circumstance.
he can
cannot
say, but he has not seen the incident.
Is he an eyewitness to the occurrence?
No, she is not an eyewitness.
So what he has stated?
He stated that
He heard from PW3.
yes,
PW3 disclosed what he had.
Yes.
So PW3 also stated same thing. So why his evidence is to be discarded?
His discarded is that his house from the spot is 5 kilometers away.
Whose house?
Arjun Naik.
Huh?
5 kilometers. Half kilometer?
Half kilometer away. One cannot hear a sound half kilometer away.
Whether he was present in the house when he heard the halla.
Where is that?
That is not.
So ଆପଣ ଯଦି ଆଣିଥାନ୍ତେ ଯେ ନାଇଁ ଆପଣ ଯୋଉ ଯେତେବେଳେ ଚିତ୍କାର ଶୁଣିଲେ ସେତେବେଳେ 1/2 କିଲୋମିଟର ଦୂରରେ ଥିଲେ ସେତେ ଆପଣ ଘରେ ଥିଲେ ଆଟଲିଷ୍ଟ ଘରେ ଥିଲେ ହଁ ତାପରେ ଆପଣ ଆଣିଲେ ଯେ ତା ଘରଟା ହଉଛି 1/2 କିଲୋମିଟର ମ୍ୟାଟର ଇଜ ଡିଫରେଣ୍ଟ
Another half kilometer from my house.
ତା ଘରଟା ହଉଛି 1/2 କିଲୋମିଟର
Yes,
ସିଏ ସେତେବେଳେ ତା ଘରେ ଥିଲା ବୋଲି ପ୍ରଶ୍ନଟାକୁ ପଚାରିକିନି ଅଧାରୁ ରହିକିନି ହାଇପୋଥେଟିକାଲ ଆର୍ଗୁମେଣ୍ଟ କଲେ କଣ ହବ ଆପଣ ଆସ୍ୟୁମ କରିନଉଛନ୍ତି ଫଟକିନି ଜିନିଷଟା ଆମେ ଆପଣଙ୍କୁ ପଚାରୁଛୁ ସେଇଥିପାଇଁ you worry the evidence that he was present in the house when he heard halla. So that is not there. Might be placed in the vicinity. There, so when he heard halla, came to the rush to this spot and saw this thing.
And the narration made by the witness is not as a hearsay witness, but in the same transaction. That is why my senior has now pointed out that this is coming within the ambit of Section 6 of the evidence.
Yes. PW4 stated that the accused was running with the alleged weapon, tangia, and 20 kg of rice. But in the FIR, it stated that the accused threw away the katari and took some one tangia and some rice.
No, you see, Mr. Counsel, PW3 even has also stated that he threw the tangia. Just come to that again line. This line is then the accused 1, 2, 3, 4, 5, 6, 7, 8, 9. So 9 lines from the bottom. Then the accused fled away from the spot, throwing of ghagda. এই জিনিসটা PW3 କହିଛି ହେଲା କିନ୍ତୁ ୱିଟନେସ୍ ମାନେ ଯେତେବେଳେ ଆସିଲେ ସେମାନେ ଦେଖିଲେ ଯେ ଇଏ ମଧ୍ୟ ୱେପନ୍ ଅଫ୍ ଅଫେନ୍ସ ଟାକୁ ନେଇକି ଯାଉଛି can it not be reconciled?
That is not the weapon of offense.
Yes,
Weapon
how
of
could
no,
they know?
he
could
threw
they
the
know?
weapon of offense and took another tangia.
Correct.
Gagda is koturi. Gagda and that
is
tangia. That tangia is also not recovered by the police. Also the rice.
No.
Yes.
You just please follow it and accordingly prepare it. The witness PW3 left the spot, and at that point of time, suppose she saw that the accused threw the tangia or the
Not
weapon.
tangia, gagda.
Oh, weapon.
Weapon.
Okay.
Weapon of offense.
So then the accused tried to flee away, but again he realized that maybe that leaving the weapon there would not be proper thing. He returned back. It might have happened, and then he took that weapon from that spot and was leaving when PW4 saw him. So you cannot say that these two things cannot be reconciled. ସିଏ ଯେତେବେଳେ ଦେଖିଲା PW3 ହେଲା ସିଏ ତାକୁ ଫୋପାଡ଼ି ଦେଇକିନି ପଳେଇବାକୁ ଗଲା ତାପରେ ଇଏ ଗଲା ଅନ୍ୟ ତା ବାପାକୁ ଖବର ଦବାକୁ କାହା ଦବାକୁ ତାପରେ ୱିଟନେସ୍ ମାନେ ଆସିଲା ବେଳକୁ ଇଏ ପୁଣି ଯଦି ବ୍ୟାକ୍ କରି ଜିନିଷଟା ନେଇକି ଯାଉଥିବ ସମ୍ଭବ
That is not in the record, my lord. It is stated that Gagda and Gagda he committed the offense, but and took another tangia. Gagda and tangia are not the same thing.
Who said that?
Yes.
Gagda and Tangi are not the same.
Not the same.
Now, where you are getting this?
Yes.
This is your argument, or you have brought it in the evidence?
Yes, in the evidence is also there.
Where is that?
In the my argument also.
Seizure list of
Where is your kind?
The accused rushed towards me with the view. I ran away at the spot. I raised halla, attention of the village people. I also in PW4 he stated. Confusing.
Exhibit 9 টা was
No, who has confused? You are getting confused, or the evidence is confused?
এটা কেতে নম্বর স্যার exhibit but not out is jo seizure টা wait this is exhibit 15 this is 14 this is 13 this is 12 this is 11 10 9 the seizure list ରେ या ଲେଖା ହେଇଛି ଗୋଟିଏ କାଠ ବେଣ୍ଟ ଲାଗିଥିବା ଲୁହାର ଗାଗଡ଼ା ବ୍ରାକେଟ ରେ ଲେଖା ହେଇଛି କଟୁରୀ ଶୁଣି ସାରନ୍ତୁ ଆଜ୍ଞା ଗୋଟିଏ କାଠ ବେଣ୍ଟ ଲାଗିଥିବା ଲୁହାର ଗାଗଡ଼ା ବ୍ରାକେଟ ରେ କଟୁରୀ ଯାହାର କାଠ ବେଣ୍ଟର ଲମ୍ବ ପ୍ରାୟ 3 ଫୁଟ 1 ଇଞ୍ଚ ଏବଂ ବ୍ଲେଡ ପୋର୍ସନର ଲମ୍ବା ହେଉଛି 9 ଇଞ୍ଚ ଯହିଁରେ ରକ୍ତ ଲାଗି ଶୁଖି ଯାଇଥିବା ଅନୁମାନ କରାଯାଇ ଏଇ ଗୋଟାକ ଜବତ ହେଲା ବୁଝିଲେ ଏଟା ହେଉଛି ଏକ୍ସିବିଟ୍ 9 ରୁ ଜବତ ହେଲା ତେଣୁ ସେ ସିଜିଓର ଲିଷ୍ଟ ରେ ଡେସ୍କ୍ରାଇବ କରୁଛି ଯେ କଣ ଗାଗଡ଼ା ଯାହା କଟୁରୀ ସେଇଆ ଆପଣ କୋଉ ହିସାବରେ କହୁଛନ୍ତି ଯେ ଗାଗଡ଼ା ଗୋଟେ ଅନ୍ୟ ଜିନିଷ
No, Gagda and Tangia are both different things.
ଟାଙ୍ଗିଆ କଥା କିଏ କହିଲା
He took one Tangia and went away. Here, I'm took another Tangia and went away. Not that weapon of offense. He threw that weapon of offense and took one Tangia and went away.
Who has stated that?
Yes, yes.
If at all it is true, that will not in any manner belies the evidence of the witness. Reason being, both the weapons. Have you brought that Tangia is not a weapon by which this injury could be there, or it is possible only in Ghagada? Is it your case? No. So both the injuries could be possible by either of these, Ghagada or Tangia. Now you say that one witness stated about Tangia, the other witness is saying about Ghagada.
No,
Yes.
that's not the case.
Then
टांगिया विषय किए କହିଛି?
टांगिया विषय କହିଛି ସେ
PW4
PW4 କହିଛି ବୋଧେ।
हाँ ନେଇକି ଯାଉଛି ବୋଲି ତ?
हाँ,
हाँ,
ନେଇକି
that is what I am saying. What you are saying now?
PW4 I am placing PW4.
Exactly. So he saw him with the Tangia.
ILM is so found running from I found the spot, we found the accused running with the alleged weapon to
Alleged weapon Ghagada.
and some rice
otherwise they ଆଣିଛନ୍ତି cross ଆଣିଛନ୍ତି
ଦେଖିଲେ ଏବଂ ସିଜିଓର ମଧ୍ୟ କହୁଛି ଘାଗଡା କଥା ତା ନେକ୍ସଟ ପେଜରେ 52
Now weapon of offense is there, no
ଘାଗଡା
ଇଏ ବି ନାହିଁ ଟାଙ୍ଗିଆ ନାହିଁ।
ଟାଙ୍ଗିଆ କୋଉଠୁ ଆପଣ ପାଇଲେ ଯେ?
टांगिया in the
PW4 ତ କହୁଛି
the weapon of offense ଘାଗଡା is generally available in the local area. ଟାଙ୍ଗିଆଟା କୋଉଠୁ ପାଇଲେ ଆପଣ? Eyewitness says about Ghagara, the person who has seen the accused fleeing away from the spot, he has also stated about Ghagara. The seizure list also indicate that it was Ghagara. And the doctor who has also verified it, that report is there. He has given the sizes and he has also stated doctor report that is exhibit ketera. Submission of at 3 acha. Submission of query report of the offense with sworn so I'm submitting the weapon etc. तार size दे ଦେଇଛି ଏତିକି 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 ଏବଂ
your lordship may kindly see the FIR. FIR. ଯାହା ପରେ ପ୍ରଚୁର ରକ୍ତସ୍ରାବ ହୋଇ ଘଟଣାସ୍ଥଳରେ ରତନୀ ଜାନି ତାର 8 ଦିନ ପୁଅ ମୃତ୍ୟୁ ହେଲା। ତାପରେ ଆସାମୀ ରୂପଧର ଜାନି ମାରିଥିବା କଟୁରୀ କେଉଁଠାରେ ପକାଇ ଦେଇ ତାଙ୍କ ଘରୁ ଅନ୍ୟ ଗୋଟେ ଟାଙ୍ଗିଆ ଓ କିଛି ଚାଉଳ ଧରି ଫେରାର ହୋଇଯିବା ପାଇଁ କୁଆଡେ ପଳାଇ ଗଲା।
He is not an eyewitness.
Yes, that is not the You come prepared tomorrow. We'll take up this matter again further. You dita decision conclusion this dita decision back to dot data ହେଲା ସାଇଟ୍ ଏଇଟା ବାହାର କରିଦେଇ ଯଦି ଖାଲି ରେଫରେନ୍ସ ଲେଖିଦବ ସାଇଟେସନ ରେଫରେନ୍ସ ହେଲା so you tomorrow you come at 10:30 sharp okay because this is the matter we'll take up